Welcome to NTD News Today. Here are today's top stories. The Supreme Court is hearing oral arguments in two cases concerning state laws banning transgender athletes from female sport teams at public schools. We will have live coverage of the hearing. President Trump is visiting Detroit today to refocus attention on U.S. manufacturing and his efforts to tackle high consumer costs. What to know about his schedule. The president is now reportedly leaning towards Iran strikes as the death toll from anti-regime protests continues to climb. Minnesota is suing the Department of Homeland Security over a surge in ICE agents. The Trump administration says the increased presence is necessary.
This is NTD News Today, live from our global headquarters in New York City.
Today is Tuesday, January 13th. I'm Alice Tang. President Trump is now traveling to Michigan today with stops planned in Detroit and Dearborn as he highlights manufacturing and economic priorities. The president is set to address the Detroit Economic Club during an event at Motor City Casino. The club says it will be Trump's third address there, and on the campaign trail in 2024, he joined a list of speakers including former presidents Jimmy Carter, Ronald Reagan, Bill Clinton, and Bush's senior and junior. Trump will also tour Ford Motor Company's historic Rouge Center, where the automaker builds its F-Series trucks. Ford says the visits will showcase American workers, putting the automobile within reach of every American. Trump was last in Michigan in April 2025 to celebrate the first 100 days of his second term. President Trump vowing that any country doing business with Iran will face a 25% U.S. tariff. This comes as the president warns he may carry out strikes against Iran over its violent suppression of anti-regime protests. We have NTD's Washington correspondent Mari Otsu with more from the White House.
I mean, there's so many of them, and some were shot. We get a full report. I'm getting an hourly report, and we're going to make a determination.
President Trump saying that the U.S. military is weighing some very strong options for intervention in Iran, as reports claim that now over 500 people have been killed in anti-Iranian regime protests.
I think one thing President Trump is very good at is always keeping all of his options on the table, and airstrikes would be one of the many options that are on the table for the commander-in-chief. Diplomacy is always the first option for the president.
This comes as the White House confirms President Trump spoke to Elon Musk about restoring the internet in Iran, where authorities have blacked out services since Thursday. President Trump's also threatening Cuba, urging them to make a deal and proclaiming no more oil or money will be sent there post-Maduro's capture.
The president's made it very clear that we don't want to see any more drug boats sailing from Venezuela towards the United States of America, which we have not, frankly, in the last week. President's also made it very clear that only oil tankers that are approved by the United States of America will be flowing from Venezuela, and we will continue to seize ships that are stateless or that are not approved for commerce.
The Venezuelan regime was long propped up by Cuba's armed forces and counterintelligence agencies. And in the 9 days since Maduro's capture, Venezuelans worldwide have been celebrating, with a group outside the White House today singing the Venezuelan national anthem.
We are appreciating the Donald Trump decision to take the control of Nicolas Maduro. We want to express he's doing the right thing, and as a Venezuelan, I appreciate what he's doing.
You have a president now that's willing to back you guys up. That goes with the Iranian people. We're with the Iranian people. We're with the Cubans. We're with people from all these countries where they have these dictators and communist movement.
Socialism is a destruction, and we see the same results in different countries as well. So if you apply socialism in the United States, I'm pretty sure you're going to have the same results as Venezuela, as Cuba. We were giving oil to Cuba for free. We were giving oil to China for free. We were giving oil to Russia for free.
Socialism, communism, the same thing. This just brings chaos to life. This country is not for communism. It's not what we stand for. We're here for freedom. We believe in freedom in every sense of the word.
Reporting from the White House, Mari Otsu, NTD News.
And with more than 2 weeks into the nationwide protests in Iran, demonstrators appear undeterred despite a brutal crackdown. The internet blackout there, now in its 5th day, makes it challenging to get the full picture of what's happening inside Iran. What began as demonstrators against inflation and soaring costs of living have now spiraled into wider unrest against the Iranian government. The regime has responded with force, arresting thousands of people and vowing to treat them without mercy. And more than 500 protesters have been killed so far, according to a US-based human rights group. We have NTD's Jason Perry with the details. And a warning, this report contains footage that some viewers may find disturbing.
In a tragic video released over the weekend, a woman could be heard crying as people walked between body bags at a morgue in Tehran. And more body bags were seen outside the morgue as loved ones attempted to identify the bodies. This comes amid a wave of protests that began over Iran's failing economy, but later shifted to oppose the Iranian regime. According to the US-based human rights activist news agency, at least 572 people have died since the protests began, including over 500 protesters and 69 security personnel. That's over 500 more deaths than the human rights group reported just a few days ago. Iran's police chief explained how they're dealing with the protests.
From now on, the police consider the situation to be one of violent unrest only, and will deal with violent rioters decisively, swiftly, and forcefully. Protesters should also be aware that by standing alongside violent agitators, they themselves become victims of the violence caused by these agitators.
According to the U.S. State Department, Chinese companies have assisted Iran in tracking protesters by providing surveillance technologies used for the repression of human rights. And the Iranian regime cut off internet and phone lines in the country last week. Some see the move as a way to help the regime stay in power, making it difficult for outsiders to know the actual situation on the ground. However, a cyber espionage investigator said things could change if President Trump helps put a satellite over Iran to enable cell phone use.
And if President Trump declares an emergency regarding Iran, and he talks to the FCC and Elon Musk, who was also stood with the Iranian people in the past and also now, can activate this service for Iran, I think this solution will turn around everything. And the people will overthrow the regime much sooner than anyone expects.
Jason Perry, NTD News.
And now the U.S. Embassy is urging Iranians and Americans that live in Iran to leave the country immediately if it's safe to do so. It says U.S. citizens should expect continued internet outages and consider leaving by land through neighboring countries. The embassy says the Iranian government has imposed major restrictions on communications and travel, including canceling flights and suspending mobile service, landlines, and the internet. The warning says U.S. nationals are at significant risk of questioning, arrest, and detention in Iran. And the Department of Homeland Security is facing legal challenges over immigration enforcement in Minnesota. The state is suing the Trump administration over ICE deployments, and the lawsuit comes amid protests following the fatal shooting of a woman by an ICE agent. Here are the details.
Minnesota is suing the federal government over a surge in ICE agents to the Twin Cities. The state is calling it unconstitutional and unlawful. The lawsuit names Secretary Kristi Noem and alleges DHS is targeting Minnesota for political reasons.
We allege that the obvious targeting of Minnesota for our diversity, for our democracy, and our differences of opinion with the federal government is a violation of the Constitution and of federal law.
The department is pushing back, saying immigration and customs enforcement is federal law enforcement and belongs everywhere that federal law applies. Acting ICE Director Todd Lyons told Fox News yesterday that ICE is present in all 50 states, and law enforcement in states like Texas and Florida cooperate with ICE instead of opposing it.
If we have ICE agents or deportation officers that are being harassed and impeded, their state law enforcement, local law enforcement actually comes to the aid of ICE, not turn down our 911 calls, not show up to a protest. We only are increasing our numbers because ICE agents are getting attacked due to the lax policies that Minnesota has.
Lyons also said that Minnesota is a sanctuary state.
They don't honor our detainers, and they release criminals back into the neighborhood.
In a press release yesterday, DHS said ICE has removed child abusers, drug traffickers, and domestic violence perpetrators from Minnesota's streets. Assistant Secretary Tricia McLaughlin said the department will not let rioters or sanctuary politicians slow it down from arresting and removing the worst of the worst in Minnesota.
And staying on the same track, Illinois also unveiled a lawsuit yesterday. It accuses the administration of creating, quote, a turmoil and imposing a climate of fear in the state and in the city of Chicago. The Supreme Court is hearing oral arguments in two cases concerning state laws banning transgender athletes from female sport teams at public schools. Let's tune in.
That's the state interest. And in Caban, the state interest was in ensuring that only children with active parents, let's say, were given a state benefit, correct?
Yes, and Caban was struck down facially. The statute was considered unjustified.
How about Lear?
In Lear, we had the same.
That's the opposite. That's the subclass, the people who were excluded.
In Lear, the court said the law would be justified with respect to you, plaintiff, and because the law would be justified with respect to you, you are not able to challenge the law elsewhere.
All right.
So the
How
court
about
says,
VMI? That distinction doesn't make any sense to me. It's still an exception. It's a subclass of people who are covered by the law and others are not. That's what we said.
The VMI case is the flip side of Idaho's law. The VMI case, equal opportunity required letting women in to previously single-sex spaces. In this case, equal opportunity for women requires giving women separate spaces. And VMI said that was okay. VMI said separate housing.
That's begging the very question at issue here. You can have a sex classification based on sex. You just have to have a reason for it and one that matches your exclusion. What you're trying to say is we don't even look at the reason to see if it has a scientific basis.
The reason we don't look at the reason in this case to see whether there's a scientific basis is because no one disputes that there is a scientific basis for separate sports.
Oh, but there is a dispute of that.
I'm sorry. Are you then saying, Mr. Hurst, that there really is no such thing as an as-applied equal protection challenge?
No, Your Honor, but what I am saying is that equal protection, the question is whether the classification is valid and not whether it makes sense in individual situations.
But that sounds to me as though, and I think our precedent is actually very sparse in this area, sort of surprisingly sparse. But it sounds to me as what you're saying is, as long as the classification is facially valid, a person does not get to come in and say that with respect to some subclass, a small subclass in this case, a person doesn't get to say with respect to some subclass, there's a mismatch, that the justification has run out, that the justification doesn't apply. You're saying that that really is just not an available argument.
I agree that is not an available argument, and I think this court has taken that approach, our approach, in cases from Conn v. Shevin all the way to Wynn, and Wynn is the best example because there the petitioner had been raised in the United States by the U.S. citizen father, and the court said Congress's interest in making sure there's a connection with the United States is enough to justify the classification. Well, this petitioner obviously had the connection with the United States. There was no basis to apply these justifications to that petitioner. Didn't matter.
I mean, one thing that this case could be about is, and this case I mean generally, this litigation, is whether the plaintiffs are right here that there is a mismatch, right? And some of your briefing addresses that question. Right, you can take all the hormones in the world, you can take all the puberty blockers in the world, you say, and there still will be a competitive advantage. That's one thing that this litigation could be about and one way to resolve this litigation. Another thing that this litigation could be about is this deeper and, as I say, surprisingly unanswered in my mind, equal protection question about what an as-applied equal protection challenge is and whether they exist. And I guess, you're suggesting that we should, well, I don't really know what you're suggesting, because here you're saying, look, just do it that way. They could be right on the science, and we would still win. A lot of your briefing really contests their view of the science. So which way should we think about this case?
We think that equal protection jurisprudence is about the validity of classifications. It takes a classification to trigger the doctrines to begin with, and then you ask, is the classification justified under intermediate scrutiny? And so that we think that's the right approach. Is the classification justified? Not is it justified in each individual instance, because as Wynn said, this court has never held, Wynn said, that a law has to be capable of achieving its ultimate objective in every instance. And as soon as that possibility of forcing the legislature to justify the law with respect to individual plaintiffs is on the table, intermediate scrutiny is over. That is strict scrutiny.
Can I question the premise that you are putting forward? Even if I agree with you that equal protection is about, is this classification justified? I think that begs the question, what is the classification? And so to the extent that you have an individual who says what is happening in this law is that it is treating someone who is transgender but who does not have, because of the medical interventions and the things that have been done, who does not have the same threat to physical competition and safety and all of the reasons that the state puts forward, that's actually a different class, says this individual. So you're not treating the class the same, and you're not, how do you respond to that? In other words, the as-applied challenge essentially redefines the class, or one could think of it as that. And so what's wrong with that, number one, and how do you square that with our holdings in Caban, which Lair later described in this way? In other words, Lair suggested that Caban was establishing that as-applied challenges of this nature do exist.
Certainly, take the second question first.
Yes.
Caban says nothing about as-applied. I know that Lair says later this was an as-applied case, but simply reading Caban, it does not say that. It simply applies intermediate.
No, I understand, but those two cases were in juxtaposition with one another,
Yes.
and Lair comes out the way it does, distinguishing Caban on the basis that it's an as-applied challenge, and we in Lair have a facial challenge, and it's basically the same facts. So if you're right, that those two cases can't come out the way they do.
I don't think so, Your Honor. Again, Lair was actually briefed as a standing argument of maybe you might be able to argue that this law is overbroad, but you individually are not in the overbroad part, and therefore you don't get to challenge it. The court didn't use standing language, like express standing language in the opinion, but that is the logic of the opinion.
Mr. Hurst,
yes.
There's another way to think about the case your friends on the other side posit, and that is that transgender status should be conceived of as a discrete and insular class subject to scrutiny, heightened scrutiny in and of itself, given the history of de jure discrimination against transgender individuals in this country over history, in immigration and family law, cross-dressing statutes. They give a long laundry list, and I'd like you to respond to that.
Certainly, on the de jure discrimination point specifically, there has been some discrimination against transgender people, significant discrimination against transgender people in the history of this country. The same can be said of many groups. The same could have been said of the mentally disabled in Cleburne, et cetera, et cetera. I think Justice Alito's concurrence in Scrimeti is helpful with this in saying this quasi-suspect class or suspect class process, what we're really looking for is classes that look like race or like sex. And if you compare the discrimination in this case, where not one of the laws they cite actually classifies expressly on the basis of transgender status, if we look at that history and we compare it to the history of African Americans and women who were not able to vote, who were not able to own property, who had express classifications based on their status written into the law for most of this country's history, these things don't compare. They're just not alike.
I'm sorry.
No, please.
Okay.
there are two things in that answer that are kind of at odds with one another. You start by saying you don't question that there's a history of discrimination, I assume de jure, in this country. Mm-hmm. And then you say, well, but they don't classify on that basis. How should we think about that?
I think that the famous footnote 4 helps, right? Has it been a discrete and insular minority? Has it been a group of people that were recognized as a group where laws were passed on the basis of their membership in that group, demonstrating that they lacked the political power to protect themselves in the political process? This is from Justice Barrett's concurrence, of course. We just don't have any of that here. All they can point to is conduct. It says, no cross-dressing, no drag performances in bars, these kinds of things. As I think our friends on the other side would admit, people cross-dress who aren't transgender. This is not a classification on that basis.
What do you do with the legislative history in this case, where the people who introduced the bill called it a transgender bar? So you in answering Justice Gorsuch, you said there's no evidence of that, but there's certainly a lot of comments in this bill when it was passed.
Your Honor, I respectfully disagree. I am aware of nothing in the legislative record that says that. I know that the Ninth Circuit opinion says that, but if you'll notice, the key quote that the Ninth Circuit relies on puts the words transgender women in brackets. And if you look up that colloquy in the legislative record, in their transcript that they provided in the district court, the word transgender, gender identity, et cetera, do not appear in that section of the transcript.
Can I go back to the mootness question that Justice Thomas talked about, but we've not addressed here at all? Yes, this respondent made certain allegations about her intent at a certain point, but she signed an affidavit with this court attesting that she has permanently stopped playing sports covered by the ban. She will not try for any school-sponsored women's sports, and in fact, I think she'll finish school very shortly. And there's no reason to question the sincerity of that belief, given that dropping out of sports puts you at a disadvantage where you lose your competitive edge, and she's going to graduate soon. How is this different than Atchison Hotel, where the person in the litigation made representations that she intended to visit and continue visiting hotels in the future, and then when the case got before us, she voluntarily dismissed those suits, like here, with prejudice, and we then directed that the case be considered moot. How is that different?
To begin with,
I add one further difference between the two cases. Here, it's not like she's attempting to avoid us reaching the question. In just a little while, we're going to reach the identical question in another case. So we don't have a subterfuge in attempting to stop the court from reaching an important legal question.
I'll start with Atchison Hotels, Your Honor. In Atchison Hotels, no one disputed that plaintiff's plans going forward. In this case, even the district court does not credit the plaintiff's plans going forward. The district court struck the notice of dismissal and said, Hecox's plans have changed before, Hecox's plans could change again, and also the court feels that this is somewhat manipulative in order to escape the Supreme Court's jurisdiction. None of that existed in Atchison Hotels, and that puts us in City of Erie territory, where in that case, the premises were sold, the business was closed, the owner was in his 70s, and they said, that's not enough. You could still reopen this business. Your company is still incorporated. Under these circumstances, where it's the respondent seeking through post-certiorari maneuvers to moot the case, that isn't enough. This case isn't moot.
Thank you, counsel. Justice Thomas.
Does the justification for a classification, as you have in Title IX, male-female sports, let's take, for example, an individual male who is not a good athlete, say a lousy tennis player, and does not make the women's and wants to try out for the women's tennis team. And he said, there is no way I'm better than the women's tennis players. How is that different from what you're being required to do here?
It's not all different, Your Honor, and that's exactly what we're concerned about, that their arguments about needing to make exceptions from an otherwise valid classification for people for whom that classification doesn't make sense, those arguments don't limit themselves to people who identify as transgender. Many males could say, I can't really compete with the women's basketball team, and therefore I should be able to try out. And I haven't seen an answer from the other side as to why they couldn't, beyond, I correct myself. They say that, well, those people don't face the same dignitary harm as transgender people. But I don't see how that's relevant to the intermediate scrutiny analysis. The analysis is this classification substantially related to legitimate state interest? The person's reasons for wanting to violate the classification don't come into the analysis.
Justice Alito? Justice Sotomayor raised the question whether the issues here are identical to the issues in the case we're going to hear in a couple of minutes, and I'd appreciate your views on that. Suppose we affirm or reverse in this case, in the other case, would that leave something undecided with respect to your case?
Yes, Your Honor. Our case involves the issue of the constitutional definition of sex, which the Ninth Circuit made a decision about, what sex means for constitutional purposes. The Fourth Circuit did not make that decision. We will be bound by that decision going forward unless the court reaches that question. That said, I would dispute the premise of the question, because whether or not the court has Article III jurisdiction in this case does not depend on what the court might do another day in a different case.
No, that wasn't the premise of the question. It was just an attempt to explore the consequences of deciding the mootness issue one way or the other. Thank you.
Thank you, Your Honor.
Justice Sotomayor?
There's a Munsingware GVR that's being agreed to here, so you're not bound by anything in this case, and our decision there will inform any new decision in the Ninth Circuit on this issue, correct? Whatever analysis we adopt in the little case will control what happens in a new case.
That is the law, Your Honor, yes.
All right. With respect to the Erie case, there, the 90-year-old man never said he didn't intend to open another business. He just said this business. And that was the distinction we saw. He or she has said, I don't intend to do this. Now, every other promise that she made in this litigation, that she was going to continue trying out, that she was going to stay in sports, held true until this case and the negative attention she received, correct? To say she misrepresented her intent is going a little extreme when she honored all her previous intents and only changed her mind when new circumstances arose, i.e., the notoriety of this case, correct?
No, Your Honor, nothing changed externally to the plaintiff. The plaintiff's affidavit filed in this court says that there has been negative attention and so forth since the beginning of this case. The only thing that changed is this court granted certiorari, and then after that, the plaintiff said, I want out, and so I will stop playing sports.
Do you dispute that having a case named after you makes your infamy live forever?
No.
You don't think that Brown and any of the other named plaintiffs that we have in famous cases drawn attention to those people as people? Have you studied your law cases? Students do all the time. I think one of my colleagues had a course where they looked at the lives of the plaintiffs. Do you doubt that having a named case with such an eventful event is going to continue attention on this person?
I don't doubt there will be attention, and I confess...
Negative attention.
I confess I have studied a few law cases, but...
have you studied the people?
To some degree, Your Honor. What I would disagree with is there's no background principle of plaintiffs get to leave the litigation whenever they want. Even Rule 41, even just the district court, the rule is that once the litigation hits a certain point, you can't leave.
So what you're going to assume, I know you don't want to, that you were to lose this case, you would say that we have to force an unwilling plaintiff who has offered to dismiss with prejudice, promised not to incur this activity again, we would force that person to continue prosecuting this case.
The court did in City of Erie.
That it did there, but is it the right thing to do? We didn't do it in Atchison.
In Atchison, no one disputed that the case was moot. The only question was which Article 3 question would be decided first. In this case, we dispute the case is moot. We dispute all of the facts that this is based on. This is a formidable burden that Hecox bears. That's from Nike, already v. Nike, to show that it is absolutely clear that this conduct cannot be reasonably expected to reoccur. We think, as the district court said in its striking order, that based on the changing history here, based on the past conduct, as Scalia mentioned in his footnote 3 of his City of Erie concurrence, there is a reasonable basis to doubt whether Hecox's current plans are the final plans. And as long as there's a reasonable basis not to credit the current plans, Article 3 lets the court hear the case.
Justice Kagan?
Mr. Harris, I want to take you back to our conversation about whether there's such a thing as applied equal protection challenges, and ask you for two things. The first is I do think that runs counter to a couple of things that we think of as basic principles of constitutional law and maybe equal protection law particularly. In constitutional law, we often say as applied challenges are the preferred mode of constitutional adjudication. Certainly, we have not erected like bars to them in any other area, as far as I understand it. And then in equal protection law, we say all the time things like people need to be treated as individuals and not as just as members of a group. And I'm wondering whether both of those principles don't suggest that any bar on equal protection, as applied equal protection challenges, is just wrong, is off. And then the second thing I want you to do after you do that is assume for me that there is such a thing, and to tell me how, in your view, an as-applied equal protection challenge ought to work in this case.
Certainly, Your Honor. The first answer would be I recognize those principles that Your Honor is alluding to. The contrary principle would be the very nature of intermediate scrutiny analysis, that it is always possible, if you only have a substantial fit supporting legislation, then it is always possible to find people whom it doesn't fit, and then we're in strict scrutiny.
So I completely take that point, Mr. Hurst. I mean, you're exactly right, and of course, intermediate scrutiny is different from strict scrutiny. It doesn't require the, almost perfection that strict scrutiny does. Completely take the point, but isn't that point really addressed to what we often consider in these areas, which is to facial challenges, right? So when you bring a facial challenge, of course, that's right, that you're allowed to have over-inclusiveness and under-inclusiveness and a lack of a perfect fit, but that the nature of an as-applied challenge is different.
Certainly the court could do that, Your Honor. The court has not done that before, as I think we both agree. And the result of that would be judge-made exceptions to laws anytime judges thought they didn't make sense for particular classes of plaintiffs. And the deference to the legislature that should exist to some degree, even under intermediate scrutiny, would be done away with. It would be gone. And then the administrability justification for many sex-based classifications, including this one, would also be gone, because you could no longer administer the classification evenly. You would have to make as many exceptions as courts thought you needed to make. So it's really an institutional competence thing or institutional power thing between courts and legislature.
So you're suggesting to me that the whole thing is just unworkable and we shouldn't, but flip to the second prong of my question, which is suppose we said, where as applied equal protection challenges exist as applied anything challenges do. What would it look like, do you think? What should it look like?
Yeah, I'm not sure what it should look like. I can say what it does look like in this case and why we think there's a problem with it.
So you're not willing to take me on my second path, which is like, let's assume that there is such a thing as this challenge.
Yes. I mean, the most I can say, I doubt this is a satisfactory answer, Your Honor, but the most I can say is that the as-applied nature of a challenge might go to the remedy. The legal analysis still focuses on the classification and the justification for the classification. And once we're talking about individuals, we're not talking about a classification anymore.
Yeah, I mean, that doesn't seem like much of an as-applied challenge, right? You have to prove the exact same thing as you do in a facial challenge, but don't worry because you only get relief as to you. So that's not a true as-applied challenge.
And I'm having trouble coming up with what it could look like, because it will always be possible to carve the class down further, right? I mean, so if they say that their class, that their subclass, I guess, subclass of males is males who identify as transgender, then we would come back and say, well, only something like 10% of males who identify as transgender take the testosterone suppression. And then they might say, well, okay, no, the class is just the males who take the testosterone suppression. And then we might come back and say, well, according to the record, according to their own expert, of males who take testosterone suppression, only 1/4 of them are able to achieve the appropriate, able to achieve ordinary levels of testosterone for women. And the other 3/4 would still have an advantage, and therefore we'd be justified 75%, pretty good fit in intermediate scrutiny, and we'd be justified with the law. But then they can just change the class again. They can say, aha, no, our class is males who identify as transgender, who suppress their testosterone, and who suppress their testosterone successfully, and are able to get it down to where they don't have a competitive advantage. And at that point, we can say, if you can define the class so precisely, you're going to force the state to define the class that precisely. It's going to be enormously burdensome for everyone, and the state can never win, because whenever the state points to the fit in the statute, they just redefine their class as only the people who are outside the fit.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
To follow up on something you were talking about, Justice Sotomayor, would your constitutional position be different if the law explicitly stated that transgender women and girls cannot participate in women's and girls' sports?
My answer to that depends on what's in the rest of the law. So I would refer back to Scrimetti and say it's not a magic words test. The mere presence of the word transgender in the statute is not enough to make it a transgender-based classification.
What would make it?
If the law, either expressly or through its effect, let all males except males who identify as transgender participate in female sports, but made it so that somebody's ability to play in female sports depended on transgender identity.
Assume that the law does not allow males to play in women's and girls' sports, and then explicitly says, a separate provision, transgender women and girls, biological males who identify as female, cannot play in women's and girls' sports. Would your constitutional position be any different in that situation?
No, Your Honor, I think that's Scrimetti. I think that would be a reference to transgender identity, but the law's application would never turn on transgender identity, so it wouldn't be a transgender status.
Even if it says transgender?
The word transgender in the statute might be relevant to a pretext analysis, but it wouldn't be relevant to facial classification if that word did not change how that statute applied in practice.
How many states allow biological males who identify as females, transgender women and girls, to play in women's and girls' sports?
Statutorily, I'm aware of 27 states that take our side and do not permit that, and 23 states that take the other side and do permit it.
And those states who do allow it, is your position that they are violating the Constitution, the Equal Protection Clause, the rights of biological girls and women by allowing that? Or do you say that's up to each state to decide, and that the Constitution gives discretion to the state whether to allow it or not to allow it?
I have not yet been persuaded by a constitutional theory that would let us use the Equal Protection Clause to impose our policy on other states in this matter.
Okay.
Justice Barrett?
I have some questions about the implications of your theory. So how would your theory play out if we're talking about 6-year-olds, where there's no difference between boys and girls in terms of athletic ability, testosterone levels, etc.? Could you have sex-separated teams then? Or sorry, sex-separated teams by biological sex and not allow trans girls on the...
Certainly, Your Honor. First, I'd like to explain how the statute applies to that situation so I can put my answer in context. There are no 6-year-olds in the state to whom the statute applies because there are no school-sponsored...
That's why it was a hypothetical.
Okay, right. Yes, it would be the normal intermediate scrutiny analysis. And are we saying it applies only to 6-year-olds or to everybody across the board?
Well, I'm just trying to give you a hypothetical. I mean, yours is driven by testosterone levels and differences in athletic capability. So I'm asking you, what if you try to take that out of the equation and you're just drawing the line based on biological sex and saying that trans girls can't be on the girls' team in an age group that's prepubescent?
The record in this case does not support the notion that males lack an athletic advantage at 6 years old. That's about as early as the science goes from what's in the record. And even at that age, males have about a 5% athletic advantage over girls in most situations. Now, if this is not a level of competition where anybody cares about that, the simple solution is the solution you see in most places, which is you have co-ed sports, you don't divide the teams based on sex, and everybody can play. And Idaho's law does nothing to interfere with that.
And remind me whether Idaho's law, and I guess your answer made me think of this, and I guess this goes to the question of whether the law discriminates on the basis of trans status. Is it true that biological girls, trans boys, can play on boys' teams?
Anyone can play on boys' teams, Your Honor.
Anyone can play on boys' teams. Okay. And to this point about medical uncertainty and scientific uncertainty, you were talking about what advantages you might have even that are apart from testosterone levels. Mm-hmm. Your friends on the other side say that, listen, that science is uncertain, and so we need more factual development. It's not really clear how much of an athletic advantage boys and men have if their testosterone levels are below a certain point. How does that play out? Tell me why we don't need more fact-finding, or what is the state's burden in showing what the state of scientific certainty is? Do we have to defer to the state? Presumably at some point, if deference is due, the state would have too little scientific evidence to really get that deference. Tell me how to think about that.
The first question would be, are we applying intermediate scrutiny? And we argue that the court shouldn't, but leaving that aside, if the court is applying intermediate scrutiny, then we'd say it's Turner Broadcasting that says the legislature, First Amendment case, applied intermediate scrutiny and said under intermediate scrutiny, the legislature has to draw reasonable inferences from substantial evidence. It does not need to act only on scientific consensus, which is what the district court in this case assumed incorrectly.
Thank you.
Justice Jackson?
So I guess I'm going back to your discussion with Justice Kagan. I'm not sure I understand why you're characterizing the as-applied challenge in practice as the individual coming back and proposing a different classification, as though we're doing an analysis of the classification in the way that you suggest. I thought that the state has a classification that is its general rule. No individuals who identify as female but were sex at birth male can play in women's sports. And that the individual then is merely seeking an exception based on their individual capacity, because the state's general rule is based on fairness and medical science and all of these things. Do I have this, like, they're not proposing an alternative class necessarily. They are just saying that I should be accepted from that general rule on this basis.
We agree that an exception is what they are seeking, Your Honor. And it's an exception based on transgender status, again.
But that's the way the rule used to work, right? I just want to be clear about what we're talking about here.
Sure.
I understood that this law originally was exactly that. That you basically said no transgender women in girls' sports, but we'll look at your evidence and look at your circumstances and decide whether or not you individually can be included. Is that what used to happen?
As a matter of Idaho law, there was no law whatsoever before this.
Is that what was happening on the ground in Idaho law?
That's what NCAA policy permitted from 2010 to 2022. Before 2010, the NCAA policy matched ours. Since 2025, the NCAA policy has matched ours.
Okay. But what I'm asking is, if that's the ask here, not that all transgender women be allowed, but that this particular plaintiff be allowed based on their circumstances, why is that so not administrable or proposing a different classification that we're not going to be able to sustain? I don't understand that.
So first as to administrability, Your Honor, making sure that a transgender athlete does not have an unfair advantage would require ongoing testosterone monitoring, because circulating testosterone can fluctuate. That is invasive. That is intrusive.
No, but that's the burden of the person. The person who wants to play, he has to demonstrate to you to whatever degree of scientific certainty that they don't have a competitive advantage. Why would you not allow that? I guess I don't understand.
The second answer is that there's nothing in that argument that limits itself to transgender identifying athletes. If this athlete doesn't have an advantage over women and therefore can compete safely, then there are other athletes that could say for different reasons that they don't have an unfair advantage and therefore they could compete safely.
Yes, and I understand that, and there are legal arguments. Let me ask you something about the classification. I guess I'm struggling to understand how you can say that this law doesn't classify on the basis of transgender status. The law expressly aims to ensure that transgender women can't play on women's sports teams. So why is that not a classification on the basis of transgender status?
I'd apply Skermetti again. The question is whether the application of the law turns on transgender status, and it doesn't. It turns on sex. The legislature did not want to exclude transgender people from sports. It wanted to keep women's sports women only and exclude males from women's sports.
No, I understand, but with respect to two individuals, a cis woman and a trans woman, who both want to play on a team that reflects their gender identity, this law operates differently based on their sex, right?
The law does operate differently based on their sex, as Your Honor just said. It does not operate differently based on their transgender identity.
But it treats transgender women different than cis women, doesn't it?
It has a disparate impact because men who identify as transgender have a different reason for wanting to play women's sports than women, than biological females do, right? But if that were enough, then Skermetti would have come out a different way, Gaduli would have come out a different way, other cases would have gone a different way. I'm blanking on the other ones.
All right, finally, let me just ask you about mootness, because it's a little odd, I think, that a defendant would not want a case dismissed. Ordinarily, the defendant is the one who's claiming mootness because they've been sued. So this plaintiff has brought a claim against you, and the claim relates to your policy about college sports. And as I understand, the plaintiff is about to graduate. So wouldn't we have a mootness problem potentially notwithstanding any representations that the plaintiff made?
I don't think so, Your Honor. I'd look to Camreta as the case that tells us the best case for telling us how we analyze mootness in this situation. It's, does the petitioner still have an interest in continuing the litigation?
Only for a few more months. What if this decision doesn't come out until June and she graduates in May?
It's my understanding at this point, I defer to my friends here, it's my understanding at this point that May graduation is not possible.
For this individual?
For this individual, that's correct.
All right, thank you.
Thank you.
Thank you, counsel. Mr. Mupan?
Mr. Chief Justice, and may it please the court. It is undisputed that states may separate their sports teams based on sex in light of the real biological differences between males and females. States may equally apply that valid sex-based rule to biological males who self-identify as female. Denying a special accommodation to trans-identifying individuals does not discriminate on the basis of sex or gender identity or deny equal protection. All of that remains true, even assuming a man could take drugs that eliminate his sex-based physiological advantages. The law is reasonably tailored, regardless of whether it is perfectly tailored as applied to any such tiny subset of men. And states are not required to redefine sex or monitor the testosterone levels of female athletes. In short, male athletes who take performance-altering drugs are not similarly situated to female athletes, and states need not treat them the same. I welcome this court's questions.
Would you elaborate on what you alluded to, and that is that whether or not a state has to, its asserted interest in classifications has to bear out in each individual case? That seems to be what the applied challenges in individual cases would require.
That's right. So intermediate scrutiny requires a substantial relation or a reasonable fit, which is not a perfect fit. And this court has recognized, and I'd point this court to Edge Broadcasting in particular, it focused on this exact issue of if the law is substantially related in general, can an individual come in and say, well, as applied to me individually, it's not. And the court said, no, we're not going to allow you to do that because that would essentially convert intermediate scrutiny into strict scrutiny on an as-applied basis. Now, I'm not disputing that you can sometimes bring as-applied claims under intermediate scrutiny. So if, for example, you had a law that applied, this sort of law that applied to sports, but also math and also chess, it might be that as applied to math or chess, it was invalid, but it was valid as to sports because for math and chess, at the level of the classification, it's not reasonably tailored. But here, critically, everyone agrees that for sports, for 99% of men, it's reasonably tailored. It's just the 1% of trans-identifying individuals who take drugs and then those drugs are effective that's a problem. And this court's decision in Michael M. makes clear that that's not a viable as-applied claim. In Michael M., this court upheld a statutory rape law that applied differently to men than women, and the rationale was because women faced a unique risk of pregnancy. But of course, if either the male rapist or the female victim was infertile, there'd be no pregnancy. So on their theory, you could have come in and said, well, I have an as-applied claim that I was infertile, so it was okay to rape the underage girl. And this court not only rejected that, the court said it would be ludicrous to say that you could bring an as-applied claim for prepubescent girls. That's just not the way as-applied scrutiny works in intermediate scrutiny cases. That's equally true, as my friend said, in Wynn. In the court's decision in Wynn, the justification for the law was making sure that the parent knew that they were the parent and had an opportunity to have a relationship with the parent. But Wynn's father knew about the birth, was present with Wynn the whole time, and brought Wynn to the United States. Nevertheless, the court held for the class of men overall, it was reasonably tailored, and they weren't going to focus on the specific facts of Wynn.
You started, Mr. Muban, by saying that you did think that there were as-applied equal protection challenges, and giving an example of, well, if it had also applied to the chess team or something. But that doesn't seem like an as-applied challenge to me. That seems as though there's just a provision of the law that's facially invalid, right? So let's put those kinds of cases aside where you can split the law up and say this part is facially invalid, this part isn't, and focus instead on like real as-applied challenges. Your classification is basically okay, let's posit, because there's a substantial relationship to your goal. Is there ever a time where a person can come in either on behalf of herself or on behalf of a subclass and say, notwithstanding that there is no a valid facial challenge here, there is an as-applied challenge, this subclass has to be exempted?
So I don't think this court's cases have ever squarely addressed that. I think if it could be brought, it would have to be a very substantial percentage. So to give you a stylized hypothetical, if you had a law that regulated on the basis of sex, and you could imagine 3 subgroups of males, for subgroup 1 and subgroup 2, each of whom are a third of men, it was reasonably tailored. But for subgroup 3, which was a third of men, it wasn't. Maybe in a circumstance like that, the third subgroup could come in and say, for a third of the applications of this law, it's not reasonably tailored. That's not enough of a substantial fit, at least for us, even if you're going to uphold the law for the other 2/3 of men.
But why does it have to be that many people? Why? I don't understand why that subclass can't make this showing and get the remedy as to them.
Because if it's one person, you're basically converting the law into strict scrutiny.
But you're not. I mean, because what you're doing is you're allowing that individual to get the remedy that we've said in cases like CASA is the only thing that's available, that you can't have this flow to everybody. It's just about this individual and whether or not he's been unconstitutionally treated.
So again, because if the law is reasonably tailored for 99.99999% of people, and you come up with a point fraction of percent and say that that person has a viable claim, that's more than you would ever require under strict scrutiny. I don't know of any.
No, but I mean, well, what's the result of that? If you're making a facial challenge, I understand that you're saying that if the law has such a broad sweep of constitutionality, then we're not going to strike this thing down just because we can identify one person for whom it doesn't apply. But if you are that one person and you can show that this is unconstitutional as applied to you, I guess I don't understand why it matters that it's constitutional as applied to 99.9% of the other people.
Well, because I think you're begging the question when you say it's unconstitutional applied to you. Laws that classify on the basis of sex only need to be reasonably related. And so if it's reasonably related because it's tailored for 99% of people, then it is constitutional even applied to you.
Even as applied to you. So you are saying there is no such thing as an as applied intermediate scrutiny challenge.
Again, if there was one where it was a third of the people, I can maybe understand a claim that the third of people, it's not reasonably related for them, even though it is for 2/3 of the people. I'm just saying that when the numbers get as small as they are here, that claim's not viable. And we know that from this court's cases. Again, Michael M., every infertile man.
No, I understand, but we didn't do that same kind of quantitative analysis in Caban, right? We didn't ask the husband in Caban to figure out where he stood relative to all husbands who were to whom this was applied.
Right. So let me talk about both Caban and Lair. So Caban is not an as-applied challenge. Caban did not say that there was some set of people for whom that law was valid. The differential treatment
itself. Lair said that about Caban.
So what Lair held was the father in Lair had abandoned the child. And what Lair essentially said is, if the mother had abandoned the child, the mother wouldn't get a veto.
Can I read to you what Lair said about Caban? Discussing Caban, Lair explained, quote, "We have held that these statutes may not constitutionally be applied in that class of cases where the mother and father are in fact similarly situated with regard to their relationship to the child." So Lair is interpreting Caban as an as-applied challenge, isolating a subset of people where there's not actual similarly situated circumstances. And Lair is different. It is a facial challenge. It is in opposition. No?
What that sentence in Lair, the facts of Lair, there was no differential treatment. The father in Lair had abandoned the child, and the court basically rejected his claim because if a mother had abandoned the child, the mother also wouldn't get a veto. So Lair's a case where the plaintiff lost because there was no differential treatment at all. Caban is a case where the plaintiff won because the classification couldn't be justified. The only way those cases would support their position is if either Caban or Lair had said there is some set of cases where the woman gets a veto but the father doesn't, and that's fine. And neither Caban nor Lair said that. This court has never said in those line of cases that the mother could get a veto but the father doesn't, and that's perfectly okay. So that's what they're arguing, and neither of those cases support it. You would also ask about VMI, so if I could just briefly address why VMI doesn't support them either. In VMI, the point was, yes, lots of women wouldn't want to go to VMI, but also lots of men wouldn't want to go to VMI. As to the set of people who were actually burdened by the exclusion, all of the women, the law was not fairly tailored. The argument that Virginia was making VMI was essentially equivalent to the following. If MIT said, most women and frankly most men can't meet our math and science standards, so we're just not going to allow women to come to MIT at all. Of course this court would reject that argument. That was the argument that they were making in VMI, that just very few women wanted to attend. But for the set of women who wanted to attend, the law was not properly tailored because there was no justification for excluding them.
Thank you, counsel. Justice Thomas? Justice Alito?
Under Title IX, what does the term sex mean?
We think it's properly interpreted pursuant to its ordinary traditional definition of biological sex, and I think probably given the time it was enacted, reproductive biology is probably the best way of understanding that.
Thank you.
Justice Sotomayor?
The problem I'm having with what you're doing now is you're doing exactly what Justice Stevens said should be done, and he admitted later in O'Connor that the court roundly rejected that in Caban and Lear. He wanted to do exactly what you said. He said, in dissent, this court should be in analyzing equal protection, contending that if the classification is justified in those cases in which the rule has its most frequent applications, then it doesn't violate equal protection. And then he said the court should presume that the law is entirely valid and require the challenger to demonstrate that its unjust applications are sufficiently numerous and serious to render it invalid. It's exactly what you said we should be doing. So you want us to accept what the dissent did and not what the majority said it was doing in Caban or Major. In BMI, Justice Scalia said the same thing, that taking the majority's logic to its logical conclusion, a single woman who wanted to attend could satisfy the admissions requirement would be enough for an as-applied challenge, and that shouldn't be the law. You're asking the court to adopt views expressed by two minority dissenting judges in this case. We've been doing an awful lot of that lately, but you're smiling because it's true, but you're asking us to adopt an approach that we have rejected as a majority court and accept what dissenters are doing, correct?
With all respect, no. Again, in Caban, nowhere in the majority opinion in Caban did they say this law is reasonable for certain classes of men, but it's not reasonable.
It did exactly. It said it's reasonable for fathers who don't support their children. It won't be reasonable for fathers who don't.
With all respect, Your Honor, it did not. Caban did not uphold that law as applied to any man who hadn't abandoned their child. Now, it is true Lair's upheld the law for someone who had abandoned their child, but the reason it upheld the law is because women who abandoned their child.
But the logic of the opinion is that if the reverse had been true, it would have ruled the way it did.
I don't think that's true, but even if you thought that was, sure.
No, I just have one last question. What's percentage enough? There are 2.8 million transgender people in the United States. That's an awfully big figure. I do understand that in Idaho, this was the first transgender child, but that just happenstance as to location. What makes a subclass meaningful to you? Is it 1%, 5%, 30%, 15%? One is not enough for you, but why?
Well, so I'll say...
When the numbers don't talk about the human beings.
So I'll say a couple of things about that, Your Honor. The first I'll say is if the distinction between intermediate scrutiny and strict scrutiny is the difference between a perfect fit and a reasonable fit, 1% surely has to be on the side that's reasonable. But if you don't want to just take the 1% on its own face, I would point your court, you want to focus on majority opinions or opinions for the court. Michael M. rejected the challenge, even though that law wouldn't, for infertile couple, either infertile rapists or infertile victims, the justification didn't apply. There are certainly more infertile people.
They did it on a different basis, which had to do with different harms.
No, that's not true, Your Honor.
Well, I can read the decision and tell you.
With all respect, that paragraph, it says, even setting aside the physical differences, it is ludicrous to think we have to exclude infertile children from this rape law. And there are certainly more infertile people than there are trans-identifying individuals who take these drugs and eliminate all their physical advantages. So if we just focus on holdings of this court, we know that this percentage is too small.
Justice Kagan?
Mr. Buban, just assume with me that there is such a thing as a as-applied equal protection challenge. What would it take to bring that challenge? What should the plaintiff have to show?
I think they would have to show that, A, they are a substantial enough percentage to be able to bring an as-applied claim, and then as to that group, the law wasn't reasonably tailored for them.
And that they would have the burden on that. It's not for the state to come back and say, the state does not have to satisfy that burden initially.
I'm certainly not the first of the two things I said. I think if you thought that you could have a valid as-applied claim, and they had made it through the gate of saying they were a big enough class, then I think, consistent with normal intermediate scrutiny, I think the state does bear the burden of showing justification for that class. So I think the state would have it on the second step, the plaintiff would have it on the first step.
I see, so they have to sort of get through the gate of we're big enough for you to take us seriously, but then the state has it.
I think that would be how you would analyze it.
And I think you were asked this, but big enough to be taken seriously? Like, how do we decide that?
You know, again, The court's cases haven't really talked about it. I think the way I would think about it analytically is the difference between intermediate scrutiny and strict scrutiny is the difference between a perfect fit and a reasonable fit. So is there enough of a group here that we think that we're not essentially holding the state to perfection? If it's so close to perfection, then you're really undermining the difference between the two. If it's a big enough group that we're not asking for perfection.
I mean, are you really undermining the difference between the two? Because usually we think of the difference between the two with respect to facial challenges. So you have to do a whole lot less to show that the facial classification that you're making is okay.
I don't think so. I do think that you would very much be undermining the difference between the two if you said that even a single person could bring an as-applied intermediate scrutiny case. And again, I would urge Your Honor to read Edge Broadcasting. There's a whole section of the opinion that's on this exact issue and says exactly what I'm saying. Now, admittedly, it's a First Amendment case, but it's an intermediate scrutiny First Amendment case.
Thank you.
Justice Gorsuch?
If the class is big enough, in your discussions, say a third, as you discussed, might it just fail intermediate scrutiny facially? I mean, at some point, do they collapse?
So I agree that that's part of why these are so unusual. If there's a big enough group that you've excluded, you're exactly right. It might not be reasonably related as a whole, and so then it facially fails. But I could at least conceptualize a situation where it covers enough people validly that a facial challenge fails, but it covers a big enough group that it can't be justified for, then maybe you could bring an as-applied claim. I don't think this court really needs to grapple with these fairly tricky analytical questions because this is the world's easiest as-applied claim to reject. It is a fraction of a percent. Whatever as-applied claim you could bring, it cannot possibly be a fraction of a percent. That would be totally inconsistent with this court's decision in Michael M. and Wynn, both of which rejected claims by people who had a much greater percentage than a fraction of a percent.
As you know, a lot of states allow biological males who identify as female, transgender women and girls to play in women's and girls' sports. And you heard Idaho say that other states, constitutionally may allow that, consistent with the Equal Protection Clause. Do you agree with that?
We've been challenging those laws under Title IX in lower courts, and as we said in our brief, we would urge the court to just reserve judgment.
Can you answer the Equal Protection Clause question that I just asked?
I'm not sure if we've taken a position on the equal protection piece.
Do you have a position?
I don't right now.
Okay, and on Title IX, footnote 2 of your brief seemed to say that you don't have a position on how Title IX applies to those states as well.
No, so we are actively litigating in lower courts, and we are saying that they are violating Title IX. What the footnote said is it's a very different question, and we would urge this court to make clear it's not resolving that question one way or the other by what it says in this case.
Okay, so you have a position on it, but you don't want us to say anything about that issue.
It's a very different question analytically, and so...
I understand, that's why I'm asking.
Yes.
Yeah. Okay, thank you.
Justice Barrett?
So, Mr. Mupan, when Justice Kagan started asking the questions early on about the as-applied equal protection challenges, she pointed out that there was kind of a surprising dearth in the case law really grappling with this. But I think you wouldn't be getting all the questions that you're getting about Caban and Lair and Michael Lamb and VMI if it weren't the case that you can read some lines of cases either way. So let's say that there is this uncertainty. We haven't really confronted it. As far as I can tell, it's because it just wouldn't be relevant in strict scrutiny because it's often fatal in fact, or typically almost always fatal in fact. So it's really an intermediate scrutiny problem. Maybe it's a rational basis problem too. I mean, maybe this would have implications for all kinds of review. Because it seems to me that if you're never talking, in any case in which scrutiny is not talking about a perfect fit, you might have this problem. What would it do, essentially? I'm just trying to think about the ramifications of allowing as-applied challenges. It seems like it's at war with the theory of intermediate scrutiny for some of the reasons that Idaho said, because all lines, all classifications overshoot or undershoot, right? So can you imagine how intermediate scrutiny works? And this isn't designed to be a layup or something. It's honestly just something I'm grappling with. How would it even work going forward?
So I'm not sure I can say a whole lot more than what I've already said, which is I do think it's a problem. The reason I think it's a problem is it's conflating the difference between strict scrutiny and a perfect fit, intermediate scrutiny and a reasonable fit. And I worry that if you allow as-applied claims to a small enough group, you're essentially collapsing the difference because you're essentially requiring a perfect fit. Because whenever you have a reasonable but not perfect fit, the subset who falls within that will come in and bring an as-applied claim. And so the state will essentially have to have perfectly tailored laws because any single person for whom you don't have a perfect fit could come in and bring an as-applied challenge.
Including, say, boys who just couldn't make the team because they weren't good enough, because the law, to the extent that it's designed to protect competitiveness and safety, et cetera, wouldn't pose the same danger in the case of a boy who just isn't good enough to make the male team, but perhaps could make the girl team.
At least arguably, depending on what their exact theory is for the justification.
Thanks.
Justice Jackson?
Yes, I'm still struggling to understand why the state would have to have perfectly tailored laws. I would think the state would just have to make exceptions where people can demonstrate that the justification that makes the state's conduct constitutional doesn't apply to them.
Right. So making exceptions is tailoring your law. That's literally what it means to tailor
No, but
law.
from the standpoint of a facial challenge, when we're asking whether this law has to be stricken completely because it isn't, perfectly tailored. What we're doing is a different exercise in the as-applied challenge. We're asking whether, even though this law is overbroad, we're assuming it's overbroad now because you've got in there some people to whom it should not be applied. What do we do about that? What is the remedy that those people can get? And what I hear you saying is they get no remedy unless they can demonstrate that there are enough people that this is sufficiently overbroad that it's no longer something the state can do.
Right.
And I don't understand why that is. Why wouldn't, when we identify people for whom this law operates unconstitutionally, that's the premise, because now I'm in remedy, right? The premise is that you have a person who's successfully made an as-applied challenge. This, to me, unconstitutional. You say, too bad, unless you can show that it's also unconstitutional with respect to a sizable number of other people. And I don't understand why that's the case.
Because I don't agree with the premise that the law operates unconstitutionally as to an individual person just because it doesn't, the justification for the law doesn't apply to that person. That's what this court held in both Wynn and Michael M. It recognized that the justification that was put forward for the law might not be true for each and every person the law applied to, but this court said that's fine.
And if we read Caban and Lair to say something different, if I disagree with you, then we just...
Well, Wynn is the most recent of the cases. So even if you read the cases that way, and Wynn is explicit about this. Wynn explicitly says, I believe it's, I'm not going to get the page number right, but Wynn explicitly says that we recognize that there are some men who were present at the birth of their child, who have a DNA test to prove that they were the father, that have been with their kids their entire life. In fact, that was probably true of Wynn's father. Tough luck.
Okay, so Justice Barrett is worried, I think she said, about the implications of allowing as-applied challenges. I guess I am worried about the implications of not. Because as Justice Kagan said, we have consistently said that facial challenges are really hard to get, that as-applied is really all there is. So now we're in a world in which you are setting up new barriers, in my view, to establishing an as-applied challenge. So at the end of the day, is your position that no matter how clear it is that the particular prescription is operating to disadvantage a particular group, that classifies you, treats you differently, you're just not going to be able to get a remedy for that individually anymore.
Let me take a step back, and then maybe this will help. Laws that classify, in general, are subject to rational basis review. Now, there's higher scrutiny for classifications on some things. For race, we have strict scrutiny. For sex, we only have intermediate scrutiny. What that means is it is okay to have a classification that doesn't operate perfectly for each and every person. So it's not the problem is that it's unconstitutional, but there's no remedy. The point is that it is constitutional,
I don't necessarily
even though
think
it's
that's the
overbroad.
takeaway. I think what that means is it's okay because we realize that in some circumstances, maybe even in many circumstances, this classification is justified. But when we can identify a situation in which it's not, I don't understand why a person can't bring that challenge.
Well, I can't say anything better than in both Michael and Wing, the court recognized that there were people who wasn't tailored for and they didn't give them a remedy.
Thank you.
Thank you, counsel. Ms. Hartnett?
Mr. Chief Justice, and may it please the court, Idaho concedes that HB 500 draws a sex-based line by categorically excluding all students with the biological sex of male from women's teams. Sex classifications like that are closely scrutinized under the Equal Protection Clause to ensure they rest on evidence, not supposition. Idaho's articulated justification for this line is to protect women's sports from birth-sex males because of their, quote, biological advantages. That means HB 500 is aimed at controlling for sex-based biological advantages, not for all of the many reasons one athlete may be better than another that have nothing to do with sex. On the preliminary record in this case, and as the experts below agreed, circulating testosterone after puberty is the main determinant of sex-based biological advantage that HB 500 sought to address. And on this record, Lindsay Hecox has mitigated that advantage because she has suppressed her testosterone for over a year and taken estrogen. HB 500 thus fails heightened scrutiny as applied to Lindsay and transgender women like her who have no sex-based biological advantage as compared to birth-sex females. That analysis would come out the other way for the untalented cisgender boy. He would have the same sex-based advantage, the circulating testosterone, he just would not be as good at sports. It also would come out the other way here, for example, if a transgender woman had gone through a male puberty and had not mitigated that advantage. This court's cases have recognized that when the government's justification for a sex-based classification does not apply to a discrete subgroup of those classified, that classification is unconstitutional regarding that subgroup. And that holding in Caban, which I'm sure we'll discuss further, has been repeatedly referred to and reaffirmed, including more recently than Nguyen and Morales-Santana. Because the court can affirm based on sex discrimination, it's not necessary to reach the question of transgender status discrimination, but HB 500 also fails on that basis. If the court does not find the case moot, the preliminary injunction should be affirmed. I welcome the court's questions.
Couldn't you make a similar argument with respect to Title IX itself and the sex difference, the permission, the fact that you can have male and female sports?
No, Your Honor. So I think the point would be, the question would be, would the sex line that's drawn in sports, and that's a line that does exist, you know, as a commonplace line, is that substantially related to the important state interest?
Well, you could have individuals who, for example, don't present the problem of physically outmatching women in a particular sport, or a group of people who don't.
Right, and the broader goal here, of course, is not sex separation for its own sake. The idea is to have equality in sports, and that's the ultimate objective that I think we're all talking about, not separation for its own sake.
Well, my point is the argument that you're making now with respect to this subcategory, could it not also be made with respect to the sex separation in Title IX generally?
Occasionally there have been examples of a boy challenging the separate teams because they want access to a team that's not available for the boys because of the way Title IX works. To be clear, we have not aware of an example of a boy challenging the sex separation so that they can be on the girls' team where there's a boys' team that exists. In that case, the courts do look at that under intermediate scrutiny, and they determine that the overall goal of ensuring equality in sport opportunity for women and men allows for the distinction.
Counsel, I wonder if you could address what has been, I think, the basic focus of the discussion up till now, which is, as I see it anyway, whether or not we should view your position as a challenge to the distinction between boys and girls on the basis of sex, or whether or not you are perfectly comfortable with the distinction between boys and girls. You just want an exception to the biological definition of girls.
Thank you, Your Honor. We're not asking for a particular definition or even really an exception. I think what we're asking for, and it is similar to the nature of the challenge that was brought in Caban. The situation there where there are unmarried fathers that were barred completely from objecting to their child's adoption. And there the father said, we'd like to be able to have that objection. We have a substantial relationship with the children. And in the group, and there was actually a pretty tailored group in that case. In Justice Stevens' dissent, he points out it has to be an older child, and there has to be a participation in the rearing for that subgroup. They were allowed to challenge that and get the relief. And so, I do note too that Justice Stevens pointed out that it was an indeterminately small subgroup of an unknown number of fathers. So I think that's the analogy that we would draw here to what we're asking.
So what would be the appropriate inquiry? And it's asking you basically for your response to Mr. Mupan in particular, that going sort of challenge by challenge, whether it's based on a transgender status or anything else in the situation, is really transforming intermediate scrutiny to strict scrutiny.
We agree there would have to be a group. I don't think, in our view, in a way, at least the way that the cases have worked out, and this is Caban and Lair, it also goes through Nguyen and Morales-Santana. I would also direct the court to the illegitimacy or the non-marital children case. Those are Trimble and Lally. They're cited in the BPJ brief. In the same way, I think the court looks, is there a definable group that's not just a person who happens to not meet the fit, but actually a group where the rationale doesn't make sense for the subgroup. But the group can be somewhat specific. Like in the case of Caban, it was actually unmarried fathers who had acknowledged paternity and had a substantial relationship. In the Trimble case, it was non-marital children who had a confirmation of paternity and a relationship with the father.
Well, that sounds an awful lot like strict scrutiny, unless you're going to say whenever you can come forward with anything that is an exception to the boy-girl distinction. In any case at all, you can go forward with the strict scrutiny challenge, whether it's 1% or whether it's 12 people, and I'm just not quite sure, grasping why your position isn't really an effort to apply strict scrutiny to a distinction that we haven't applied it to.
Thank you, Your Honor. I mean, all I can say, and I do agree the cases are not that many in this context. I think it's possibly because facial challenges were more in vogue before, and now as applied challenges are more preferred, and so that may be explaining why a statute in Caban, for example, wasn't viewed as carving out the statute for the people it couldn't be applied to versus facially invalidating it. But I do think it matters because it's not just a matter of fit that makes intermediate scrutiny different. There also has to be an important government interest, not a compelling one, and this is really critical. You can burden the right in intermediate scrutiny. So in Nguyen, for example, that person failed because he actually didn't take the steps that would be needed to confirm the paternity. So you're allowed to actually, he may have had a compelling case on a one-off basis that, hey, I actually do have that relationship with the citizen father when I was born abroad, but he didn't take the steps that he needed to do. The same thing with Lair, and the same thing with Lally and the Trimble-Lally line. So you can actually burden the right by saying, Lindsay Hecox has to actually submit testosterone tests or something else different than other people, and that would not be allowed if it were strict scrutiny.
And if we follow your approach, which allows a challenge to even a fairly small group that's affected, in what way would we not? That would apply across an entire range of things where there's a distinction currently between boys and girls, quite apart from just athletics. Is that correct?
Your Honor, I do think that the question would, I think we're not trying to invent something here. I think we were trying to draw from what we understood to be precedent from the court, and I would direct you to the Equal Protection Scholars Brief. They have some scholars that have actually focused on this question of what does an as-applied challenge mean in the equal protection context. But I think taking a step back, the question always would be looking at what the state's asserted interest is here. And here the state is not asserting an interest of having the boys' teams be better and the girls' teams be worse. What they're trying to do is control for a sex-based biological advantage. And so I think a lot of the hypotheticals that you can maybe understandably think about, what about the untalented cisgender boy? What about the transgender woman who didn't mitigate? You know, what about this or that? That gets taken care of because the testosterone is the advantage on this record, and almost all the people that might want to try to get an as-applied challenge under some other idiosyncratic framework would not be able to show that their exclusion actually was.
Okay, and this will be my last
please.
question. My point was more that how we approach the situation of looking at it not as boys versus girls, but whether or not there should be an exception with respect to the definition of girls. That would, if we adopted that would have to apply across the board and not simply to the area of athletics.
I mean, I think it's a general framework for equal protection challenge that, again, predated this case, this litigation. There have been boys that have tried these challenges in the past. They generally have failed because they actually don't lack the opportunity, or actually are treated, they're not being treated differently than similarly situated individuals.
You said, Ms. Hartnett, that you're not talking about individual by individual by individual. It has to be a defined group. So how big does the group have to be? How does it have to be defined? And why are there those requirements? If what you're saying is right about equal protection law, why wouldn't it extend to individual by individual by individual?
I don't think the court has foreclosed that, other than this actual obvious conceptual question of, like, when do we get towards strict scrutiny? I think what I could tell you is that in the way that the court looked at it, from Caban to Lair to Nguyen to Morales-Santana, and then also Trimble and Lally for the case of non-marital children, the court seems to usually be trying to figure out not just is this individual somehow idiosyncratic, but are they part of a group that actually doesn't make sense to exclude? And that makes sense because usually you're trying to figure out, is the interest served by the exclusion? And there's usually some principle why a subgroup was not properly included.
And what are the requirements of, what does that group have to look like? Mr. Lupin suggested that it has to be, fairly sizable. It can't be 1% or less. Why not? Why? What are the other requirements? Like, how do you go about defining which group, which subclasses get to make this challenge and which subclasses don't?
That's a good question, Your Honor. I think in Trimble, this is again the non-marital children case and cited in the BPJ brief, they said discrete categories that were unnecessarily excluded. That was the notion there. So I think that's where we were trying to make clear that we don't think it can just be, we have a person that is extraordinarily idiosyncratic and they should get their case. And I don't think anything in your cases rules that out. I guess that's not actually the case presented here. We think we have an easier case because we actually have identified a discrete subgroup, transgender women who do not have an athletic advantage.
But I don't think you're answering Justice Kagan's question, which is fine. If you buy into you have this subgroup as you've identified it, Mr. Mupon says that subgroup has to be big enough. Do you agree? And if so, how do we evaluate that?
I don't agree with that. I think that is I think in a way this is the Caban dissent kind of coming back after many decades, because there, Justice Stevens said in the dissent, he's assumed that the case in that case was assuming that the case extended only to himself and by implication to an unknown number of fathers, and went on to say indeterminately small part. So I think there's never been a numerical requirement. It's more of a question of whether there's a principle that, some sort of a principle that allows for the exception in light of the failure to align with the interest that the state's asserting. And here, I think the record, and again, we're at a preliminary injunction stage, but the preliminary record was that the exclusion of our client actually was not going to advance the interest, nor the exclusion of other transgender women who do not, who have taken efforts to mitigate their testosterone, which was on the record here again, was the main driver of differential athletic performance.
Counsel, one might wonder whether the efforts to refashion our equal protection jurisprudence here that we've been discussing at length on sex discrimination is really a fallback from what one might wonder might have been your primary argument, which is that transgender status is itself a discrete and insular class. And I'm curious why you haven't brought that up and what thoughts you want to share with us. Your friend on the other side said the laws you pointed to in your brief don't address transgender persons as such, and that makes all the difference. Thoughts?
Well, thank you for the opportunity to address that. I think we were trying to find the most straightforward way to help the court to an answer here, and I think we do.
I've been wondering what's straightforward after all this discussion.
No, I understand. I think these are older cases, but it's very interesting to see the debate between the majority and Justice Stevens, and Justice Stevens and O'Connor kind of admitting that he was applying his dissent in Caban. So these are cases from the court. We think they have some force. But to the question you've asked, I do think it's important to begin with, you heard my friend on the other side talk not about cross-dressing or other laws. They didn't have any response to our point, because there isn't one, that transgender people were categorically excluded from immigration to this country under an overall umbrella of being a psychopath. That was the actual decision of this court in the Boutelier case. It was interpreting language of Congress that determined that when Congress used the term psychopathic personality to exclude people, they meant to include homosexuals and other sex perverts.
Perhaps
and
not our finest hour.
Well, it's not your fault, but I think that.
Thank you for that.
No. Well, it was by reference to a congressional report. They were trying to figure out what did Congress mean, and there actually was a public health service report. I would direct your attention to it because I think it really does go to the level. I was surprised when I read this document. It's 1952 UScan 1653 at 1701, trying to explain why sex perverts would include homosexuals, transvestites, which was the name of the day for transgender people. The term transgender did not become more common till now. So I think reading Boutelier and reading the UScan that's cited in Boutelier is instructive. I also think that the laws on cross-dressing, I think that's an interesting point, because what that actually means as a practical matter for the transgender person was that they weren't allowed to leave their home as themselves to enjoy all of their civil rights. And I don't think, we don't want to exaggerate it, but we also don't want to understate it. There were major cities in the country, Chicago, others, that actually barred you under subject to criminal penalty for leaving your house in clothes that weren't matching your gender. And people were actually prosecuted under those laws. So again, I appreciate, and we're not saying you have to have the same history. We're certainly not equating the experience of the transgender community to that of Black Americans or of women. But just as illegitimacy or non-marital children has been recognized as a class that gets closer look, I think we respectfully submit here it would make sense to do so. We appreciate, though, this is a question that the court hasn't recognized a suspect class for a long time. They also haven't shut the door to a suspect class since Cleburne. So I think we prefer, to the extent the court was still finding another path forward, the reason why we tried to help you find a way to answer the question here based on sex discrimination.
Well, to pick up on the issue of discrimination on the basis of transgender status, let me go to some basics. Do you agree that a school may have separate teams for a category of students classified as boys and a category of students classified as girls?
Yes, Your Honor.
If it does that, then is it not necessary for there to be, for equal protection purposes, if that is challenged under the Equal Protection Clause, an understanding of what it means to be a boy or a girl or a man or a woman?
Yes, Your Honor.
And what is that definition? For equal protection purposes, what does it mean to be a boy or a girl or a man or a woman?
Sorry, I misunderstood your question. I think that the underlying enactment, whatever it was, the policy, the law, we'd have to have an understanding of how the state or the government was just understanding that term to figure out whether or not someone was excluded. We do not have a definition for the court. And we don't take issue with we're not disputing the definition here. What we're saying is that the way it applies in practice is to exclude birth sex males categorically from women's teams, and that there's a subset of those birth sex males where it doesn't make sense to do so according to the state's own interest.
Well, how can a court determine whether there's discrimination on the basis of sex without knowing what sex means for equal protection purposes?
I think here we just know that we basically know that that they've identified pursuant to their own statute, Lindsay qualifies as a birth sex male, and she's being excluded categorically from the women's teams as the statute. So we're taking the statute's definitions as we find them, and we don't dispute them. We're just trying to figure out, do they create an equal protection problem?
All right, suppose this school that has a boys, let's say, track team and a girls track team. The school has that. And a student who has the genes and the reproductive system of a male and had those at birth and has never taken puberty blockers, never taken female hormones, never had any gender altering or affirming surgery, says, nevertheless, I am a woman. That's who I am. Can the school say, no, you cannot participate on the girls' team?
So you're just a birth sex male who has all the advantages of birth sex male hormones, and can the school bar him from the women's team? Yes, they can.
But that person, is that person not a woman in your understanding? If the person says, I sincerely believe I am a woman, I am in fact a woman. Is that person not a woman?
I would respect their self-identity in addressing the person, but in terms of the statute, I think the question is, does that person have a sex-based biological advantage that's going to make it unfair for that person to be part of the women's team? And that's the rationale for the regulation, and so that's the way we would be testing that hypothetical.
Well, the reason I'm asking has to do with discrimination on the basis of transgender status. So what you seem to be saying is, yes, it is permissible for the school to discriminate on the basis of transgender status, because if this person is a trans woman, a trans girl, and is barred from the team, from the girls' team, then that person is being subjected to differential treatment based on transgender status, right?
Well, that would be, then the question would be whether it was, the scrutiny would be satisfied. So from our perspective, that would be a transgender classification. It would get heightened scrutiny, and it may be satisfied here because of the need to have, to curtail unfair athletic advantage. That would be the analysis. We are not pressing in this case the notion, and the case does not require the court to decide whether transgender women who've gone through puberty and have not suppressed their testosterone would be able to play on a men's team. And the record here is a preliminary one where that doesn't present that question for the court.
When this does present a particular factual situation, and we have to decide that case, but looking to the broader issue that a lot of people are interested in, there are an awful lot of female athletes who are strongly opposed to participation by trans athletes in competitions with them. What do you say about them? Are they bigots? Are they deluded in thinking that they are subjected to unfair competition?
No, Your Honor, I would never call anyone that. And I think what we're saying here is that you have to, that's the reason why there is intermediate scrutiny, or even in rational review, you don't legislate based on undifferentiated fears. You base on trying to make a rational response to what is a perceived issue. I think here, although I would take issue with the notion that there was no reference to transgender individuals in the creation of this law, I really would direct the court to JA. Again, this is not about animus. I'm just saying that if you look at JA, pardon me, I need my JA 105 through 112, there are numerous references to from the sponsor of the law saying the way we're going to try to protect women's sports is to not have transgender women play on the women's teams, and that was the fear that they had at the time. Again, that is not an accusation of animus, it's just a question of what was the statute doing, and then we go to the point of, does the statute survive heightened scrutiny? That would be the inquiry.
Do you think that the success of trans athletes in women's sports is proportional to the percentage of trans athletes who participate in women's sports?
I think I would direct your attention to, there's I want to make sure I have the right amicus. There's an amicus brief that talks about actually some of there are examples, obviously, of some transgender people that have participated and excelled. They actually are few and far between. You know, we have our client here who tried to make the NCAA team because of the injunction. She was too slow. She played club soccer, club running. She was even an officer in one of those clubs, just doing what you would hope a college student would do. You'll hear from my colleague about the other case. But I do think that, and there's a brief that you, in the amicus briefs, that will share the examples of showing that's a bit overstated.
Would the analysis be different if they were more successful?
No, I think it would be, to the extent, I mean, we've already covered that transgender people are a meaningful slice of the population, but a small slice. I think the state, if there were a concern of women's sports being fully overrun by an outbreak of a huge new number of transgender people, that might be a different factual situation. In the end of the day, and we understand that there were legislators who were concerned about that. The legislative history makes that clear here, but that wasn't the factual basis before the court. If there were actually a threat to women's participation in women's sports, that could be a different analysis, because obviously the goal of sex equality in sports is a very important goal. We don't take issue with that. We just would say that I think this is an important moment to just take a step back and say, is this law actually responding to a problem in a rational manner, or is it actually overreacting on the presumption that transgender women are categorically going to be strong athletes when that's not the case?
Well, just to put the big picture, and you know this on the table, and let you respond to it, but obviously one of the great successes in America over the last 50 years has been the growth of women and girls sports, and it's inspiring. And there's some states in the federal government and the NCAA and the Olympic Committee, so these are a variety of groups who study this issue think that allowing transgender women and girls to participate will undermine or reverse that amazing success and will create unfairness, because you said if large numbers, well, for the individual girl who does not make the team or doesn't get on the stand for the medal or doesn't make all league, there's a harm there. And I think we can't sweep that aside. And I think that's what's undergirding some of the concerns, big picture, and there are harms on both sides. So I completely understand that, but I just want to let you respond to that, because that is, the NCAA, the Olympic Committee, a lot of states, federal government, that's a lot of people who are concerned about women's sports and think this raises a big problem. And I just want to make sure you can explain that.
Thank you, Your Honor. And just to be clear, Title IX is a huge triumph, and I'm a veteran of women's sports myself. So I'm glad it exists. It's made a huge difference in our society. That's not what we're talking about here. But I do think, to the point of, for the podium question, I think the question is there an unfair biological advantage? That would be the question. So I understand the point. If there is somebody who's coming in with an unfair biological advantage, that would undermine the entire point of separate sports in the first place, which was to allow women to have a place to thrive, to be strong, to win, not to just be the B team. The question in this case is if the person had actually mitigated their sex-based advantage, which maybe interestingly, maybe counterintuitively, actually is more about circulating testosterone after puberty than a lot of the other things we might think are sex-related, then that girl that's come in second to a transgender person that's mitigated actually may just have come in second because the transgender person was similarly situated, but was stronger in that one competition. That's why we are here not proposing a rule of absolute inclusion, but saying that in the case with people like our client who have mitigated, their exclusion doesn't match the statutory interest.
Counsel, can I ask you a question about analytically in the discrimination on the basis of transgender status? Since trans boys can play on boys' teams, how would we say this discriminates on the basis of transgender status when its effect really only runs towards trans girls and not trans boys?
We understand the point, and I think that might be relevant to for example, animus point, right? There were not a complete exclusion of transgender people, there was an exclusion of transgender women. But I think on that piece, this court has never required the whole class to actually be excluded to look at the cases to whether the exclusion of a subclass was proper.
I'm talking about for triggering intermediate scrutiny if transgender status is a suspect class.
Right, so like Craig B. Bourne, for example, that's the one about the men that couldn't get the 18 to 20-year-olds, right? That wasn't all men, it was a subset of men, and yet the court still viewed that as a sex classification subject to heightened scrutiny. And likewise here, even though it's just transgender women, in our view, that are being barred and not transgender men, that also would trigger heightened scrutiny. And I think there's the Rice v. Cayetano case from 2000. There's other examples of the court making clear that just because a subset of the protected class is being excluded, you still would apply heightened scrutiny.
Another question about the science. So you were talking about circulating testosterone being kind of the marker. Idaho is saying, well, that's not the only indication. There are other, when I asked the question about 6-year-old teams before that there are other just kind of genetic hardwired differences, maybe in size, et cetera, that don't have to do with circulating testosterone. Is it your understanding that testosterone is it?
So, and my colleague who will present the argument in the next case, that the record there was more about prepubertal and puberty. Right. I think that the 5% even is not clear whether that's just environmental or biological, actually.
Right.
But I do think, so there are other things that I think, like height, bone size, there have been some other discussions of this. This is an underdeveloped record, by the way. This needs to go back and have a full trial, except that it's moot. But I think the point there is that, no, I'm not trying to make a point on that. I'm not trying to pretend that I'm going to have a trial when we're not. Yeah. But I think the point is that sometimes counterintuitively, it's like having a larger frame, but not having the muscle and the testosterone to drive it could actually put the person in a worse position. And that's a study that was commissioned by the Olympic Committee. It's footnote 6 of our brief, indicates that actually it could be put the transgender woman at a disadvantage if they happen to have larger bones and less testosterone or muscle to drive those bones.
Last question. So below, as I understand it, your client challenged the verification procedures.
Yes.
Except when we were talking about how this might be administered, I understood you to say that it would be by checking testosterone levels, because it would be okay to say, to Justice Alito's hypothetical about the cisgender male who has taken no steps and who is now trans to exclude that person. But would that be an invasion? Would that be a violation itself, or too invasive to require someone to, and maybe not just once, but maybe to periodic testing to make sure that the circulating testosterone was low enough? Why wouldn't that be invasive?
So that's an ordinary blood work that a transgender person would get, and that's why I think it's of the nature of the minimal burdens, like in Nguyen and the other cases where the court has said intermediate scrutiny applies, and you actually can, if there's minimal things you have to do to make yourself fall in the category that we want to keep protected, we can require that of you. But
didn't you challenge it?
Well, that was different actually, because the three things that you'd have to prove under the state's novel verification thing would have to be your genetic, your reproductive anatomy, which would require actually like a pelvic examination or examination of someone's, nude area. It would be chromosomes, which would require chromosomal testing. That's not what we're talking about. Or it would be endogenous testosterone. And the reason why that wasn't a problem is not because of a blood test. It's not invasive. It's because it would have required the transgender person to stop their hormone treatment to get back to an endogenous level to be able to show they're endogenous.
Okay, so the distinction between circulating and endogenous.
Right, the point was that was actually in a way, like, and I'm not trying to cast aspersions, but kind of a false requirement for transgender people, because they aren't on their endogenous testosterone when they're on hormone therapy. They're on a non-endogenous medical treatment.
Thank you, counsel. Justice Thomas? Justice Alito? Sotomayor?
I'd like you to address mootness because you raised it with Justice Barrett. Is this case moot? Could you respond to the other side's positions or arguments as to why it wasn't? And how do you respond to that? Secondly, Justice Barrett did raise earlier, this law applies even to primary schools, correct?
Taking your second question first, yes. I don't think it's in the record whether or not there are any primary schools, whether they sex separate or not, but that is the law.
And so, at least as to that subgroup, no one could doubt that primary school children might have the strongest argument that there's no difference in their physical makeup that would cause harm or otherwise create an advantage, correct?
That would be our position, Your Honor. In this case, we had both our client who was at college at the time, and then we had a high school intervener who was worried about being subject to the sex verification, so we didn't really get into the building a record on the
But the point is that the law might be overbroad in many ways.
Certainly, yeah.
And there's still, as you noted, Idaho was the first or the second state to pass this law?
It was the first. I mean, these cases come to you because they're early ones.
And the record here was the most underdeveloped, correct?
Including because it was a preliminary injunction. There was a substantial amount of expert material in the record that allowed the district court to make appropriate findings, but it was not the level that you build up for a trial.
And both courts said that the record had to be looked at more carefully.
Expressly, they did.
All right, so answer the mootness question.
I mean, Your Honor, all I can say is that we've tried to provide the court with accurate information as soon as it came to pass. In 2024, when we opposed certiorari, our client still was active and intending to play sports. The court granted the case. She was preparing for what she hopes is her final year of college. She was concerned about the increasing hostility and the visibility. I mean, we're here now, and that's okay. She understands she brought the case, but that was the basis for her trying to end her sports career. And it isn't contrary to what she said before. She did intend to play sports through college. Her college has taken a long time. She's now sworn she will never play sports that are covered again, and she won't do that even if she happens to somehow win this case. So that is just the truth. But whether the court believes it's moot, that's, we put the facts before you for you to decide.
How about her graduating this year? There was a suggestion she might not.
As you can tell, we have college students have so she is trying her best to get through college. I think at this point, and I'm just basing it on what I know of as of today, she's unlikely to graduate by May, as my friend said, but is hoping to make through summer credits, could graduate in the fall.
Finally, in terms of the sports teams, the Olympic team, that all happened in 2025 after our president directed them to.
We do think that's worth parsing out. Again, there's been a lot of contentions made on both sides that are extra record, but I do think a lot of those things flowed from the executive order. There were some other sports orgs that were doing different things, but I think we have to be careful not to broad brush that because some of it may have been political, some of it may have been scientific, and the record really isn't fully before the court.
Justice Kagan?
Ms. Hartnett, I just want to get your understanding of what constitutional review would look like in this context. So you said it's not individual by individual. You have to come in and say there's a class that's not being treated appropriately. What is that class here?
Thank you, Your Honor. And I would say I don't think the court has ruled out the individual case. I just think we weren't presenting it that way because we were trying to align ourselves with how the court had looked at it. I think we would say we represent the group of people that do not have an athletic advantage, that have mitigated their their biological advantage of being born male.
So who do not have an athletic advantage, I mean, for reasons of taking certain medications or hormones or
no sex-based biological advantage. So it would encompass both people that had gone through the male puberty and had mitigated. It would also encompass others like that have not yet gone through puberty or that staved off puberty with the puberty blockers.
And as to those people, who has the burden of showing that the justification doesn't fit?
I think I think once we've identified the subclass under intermediate scrutiny, it is the state's burden to show a substantial relationship for that group, and they failed to, and that's how those other cases proceed.
You wouldn't think that because we are talking about an as-applied challenge to a law that's facially everybody can see is legitimate, that the burden should shift to you?
I don't think that's how the cases looked at it when they were assessing. They were kind of assessing whether the state had provided enough to allow the exclusion. For example, in Lair, the state had made an adequate showing to show why the parent in that case was properly excluded.
And how do you think the question of scientific uncertainty should play out in an analysis like this?
Thank you. That's a good question, and I know this was something the court did address in Scrimeti, a rational review case, but citing Carhart, which also talked about that. I think the one thing we definitely want to have is complete findings, so that's why we really were urging to have a full record developed before there were any final judgment of scientific uncertainty. I think the court has not fully grappled with what does scientific uncertainty mean and how does it come into conflict with heightened equal protection scrutiny, but I think we don't need to present that yet because on this record, there was not uncertainty. This person had mitigated, testosterone was the determinant. Maybe on a later record that would come out differently, but I don't think that.
Just play it out a little bit if there were scientific uncertainty.
I mean, if it really were an equipoise, then I think that that is a situation where I think it's still heightened scrutiny. So under heightened equal protection scrutiny, the burden is on the state to justify the law, and if they haven't been able to justify that, that usually fails. If it's really a question of they're at 50-50, do we allow the state some leeway? I don't think that's been answered in the court's cases. Normally, the heightened scrutiny controls, and there's not a deference on top of that in the equal protection context.
Thank you.
Justice Gorsuch.
Just to follow up on that, I wonder if that starts to sound like strict scrutiny, because the point of intermediate scrutiny, of course, is some leeway for the state, not a perfect fit, at least in the facial area. But if there's scientific uncertainty about whether puberty blockers and testosterone suppressants completely or mostly or some percentage of the time eliminate all competitive advantage, some competitive advantage. I mean, you've been very careful, I think, and rightly so, to talk about mitigating advantage. But I don't know, does the state have to show that it eliminates advantage and it doesn't eliminate, some percentage of advantage remains in each individual case, or for the group as a whole? I'm struggling to understand your response to Justice Kagan on that score. Maybe I'm inartfully posing the question, but I hope you understand.
I do understand your question. I think the question is at some level, I think the question is where you have science that's developing in real time at some level, what happens, how does that dovetail with a state that's trying to regulate and do that? I think what we can say on this record is the categorical exclusion is really not supported, I don't think, by any science. This again was from kindergarten through college. And so there'd be some subgroups at least. And I think there has to be an effort to try to tailor it. I think here the problem was there was a reaction of transgender women, a picture of what that would be, kind of an undifferentiated fear, frankly, from the Dearborn case. And so I think
I appreciate all of that, but it seems to me from my glance at the record, and quite a record it is, and, that there is a healthy scientific dispute about the efficacy of some of these treatments, and that's understandable. And I'm just wondering, how does that fit with, assume there is some dispute, and I understand the record remains to be developed further, but how does that fit with intermediate versus strict scrutiny?
At the end of the day, it's the state's burden to show a substantial relationship, and I think in the case of something where they're doing their best and have the best evidence some evidence to support what they're doing.
Some evidence, the best evidence, exactly. I mean, that's
a level of evidence that wasn't met here. So the study and the findings. I mean, the district court made a really good point. That study had actually been retracted, and it didn't pertain to transgender athletes. So in a way, this is not the hardest case. I appreciate it as a hypothetical. I guess what I would just urge in this area that's sensitive, obviously politically, but also as a matter of science, to at least let a record develop in one of these cases that lets you decide, actually, is this
I totally agree
50-50 versus 80-20? That's
all right, but 50-50, does the government win? Does 70-20 the government win? That's what I'm getting at. I understand the complexity of the record and the difficulty of the science, but if we're going to have individual cases brought, that's the kind of question we're going to ultimately have to answer. Not the science question, but the percentage question, if you will.
No, I understand that. I mean, VMI does provide some sort of a metric of what we would do there, which was we looked to see there were kind of evidentiary debates on both sides of that. But even if you could say that a lot of women may not have ever made the cut, the fact that there were some that did was enough to invalidate the entire policy. So I think there are ways for courts to make those judgments, and I think the court has not yet, I think, encountered a case where heightened scrutiny puts a heavy burden on the state. It's not an insurmountable one like strict scrutiny normally is. And then what happens if it ends up with the evidence being a tie or close to it when we go back to the trial court? I think that would be that would be breaking some new ground, because I don't think there's an equal protection case that decides that issue. Usually the evidence is kind of clear on one side or the other about whether the restriction is justified.
That would remain for us to decide at a later point.
I do think that's the most prudent, but definitely on a record that's more developed, because I think I think in the end of the day, it might end up being a surprise we don't know yet, but I think we have some good evidence that actually at the end of the day, being a transgender woman, actually to the extent there are, and you've repressed your testosterone, you're at somewhat of a disadvantage in many ways, because you have, again, this larger frame with weaker muscles and no testosterone.
Thank you.
Justice Kavanaugh?
Just to follow up on Justice Gorsuch's question, a broader.
Now that was live from the Supreme Court, where justices are hearing arguments on laws banning boys from playing in girls' sports. Idaho Solicitor General was just arguing for the ban to remain in place, saying testosterone levels and athletic ability can always change, which is why the ban is necessary. He said without the ban, continued testosterone monitoring can be invasive, and also that the law operates on sex, not on gender identity. And that's all we have for this hour. If you have any feedback on the show or have something you'd like to see us cover, send us an email at news.today@ntd.com. We'd love to hear from you. For round-the-clock original news coverage, watch us live at ntd.com/live or download our NTD app. We'll cover more news right after this break.
Shenyun Creations, the streaming platform from Shenyun, featuring world-class dance, past programs, and all original music. Masterclasses, behind the scenes, comedy, and more. Explore shenyuncreations.com.
Is deep-sea fish oil really healthy? Due to pollution in the oceans, most fish contain heavy metal elements and radioactive substances. That's why it's so important to choose a pure source of omega-3. Puritang Green Vegetable Omega-3 is made from purslane and perilla seeds, which are rich in nutrients and minerals. It effectively improves brain power and is beneficial to the heart's health. Puritang Green Vegetable Omega-3. Eat 2 a day and you'll feel brand new.
This is how I keep my joints happy.
Omega XL is a powerful natural supplement backed by 40 years of clinical research. Take control of your pain, like Cynthia Bailey.
My knees in particular started giving me pain issues all the way back to my modeling days, from just running through airports, photo shoots. After taking Omega XL, I really started to notice how less stiff I was, especially my knees and my hip. Has Omega XL changed my life? Yes, I barely notice my joint pain anymore. Now I'm like literally sprinting through the airports. My secret is Omega XL.
Pick up the phone and call now to get this exclusive TV offer. Buy one Omega XL and we'll send you a second bottle absolutely free. You'll also get a free bottle of Vitamin XL D3. Buy one, get two free. A total value of over $115, all for just $49.95. You save more than 55% and shipping is free. Backed by a money-back guarantee and is not available in stores. Operators are standing by, so call now.
You'll help provide hot meals, safe shelter, medical care, and love. We'll send you this comforting blanket as a reminder of the love you're showing a young person this holiday season. Call or go online now to safeplacetosleep.org, and your first month's gift will be matched.
There are real consequences to controlled media. And NTD's founders know them firsthand. Our freedom of thought is the price. This is the lesson that guides us in everything we do.
So there's the tear gas there.
We know the value of a free society. And we take seriously the responsibility to preserve it. We are NTD.
Welcome to NTD News Today. Here are today's top stories. The Supreme Court today faces a decision that could reshape women's athletics nationwide. We speak with a civil rights attorney for analysis. The Trump administration ends temporary protected status for Somalis. The decision comes as Minnesota faces a widespread fraud scandal. President Trump is visiting Detroit today to refocus attention on U.S. manufacturing and his efforts to tackle high consumer costs. What to know about his schedule? The House Oversight Committee said it will seek to hold former President Bill Clinton in contempt of Congress. That's after the former president and his wife Hillary Clinton refused to testify in the House's Jeffrey Epstein investigation. And President Trump is calling on the Iranian people to take over institutions run by the regime. What the president says about America sending help to the protesters.
This is NTD News Today, live from our global headquarters in New York City.
Today is Tuesday, January 13th. I'm Stephanie Cox. Former President Bill Clinton could soon face contempt proceedings. The Republican chair of the House Oversight Committee says he's starting that process. That's after Clinton failed to attend a hearing this morning on sex offender Jeffrey Epstein. Here's Committee Chair James Comer.
I think it's very disappointing. As a result of Bill Clinton not showing up for his lawful subpoena, which again was voted on unanimously by the committee in a bipartisan manner, we will move next week in the House Oversight Committee markup to hold former President Clinton in contempt of Congress.
A spokesperson for the former president has said that Clinton knew nothing about Epstein's crimes. Former Secretary of State Hillary Clinton has a similar deposition scheduled for tomorrow. Her attorneys say she won't show up either. Lawyers for the Clintons are calling subpoenas from the committee invalid, saying they're legally unenforceable. Former Justice Department Special Counsel Jack Smith will testify publicly before Congress. The hearing will take place on January 22nd. The testimony will be before the House Judiciary Committee, which is scheduled for 10 a.m. Eastern. Committee Chairman Jim Jordan confirmed the date yesterday. Smith brought 2 criminal cases against President Donald Trump. Both have since been dropped. Smith previously testified in private in December. During that session, he defended his investigation into the president, telling lawmakers the prosecutions were based entirely on Trump's actions. President Trump has said that the cases were an abuse of the legal system, citing political motivation. And the number of reported deaths in Iran keeps rising. President Trump is now directly calling on the Iranian people to dismantle institutions, saying help is on the way. Trump took to social media this morning saying Iranian patriots, keep protesting, take over your institutions, save the names of the killers and abusers. They will pay a big price, unquote. Trump also announced that he canceled all meetings with Iranian officials until the regime stops killing protesters. The president ended the message by saying help is on its way, make Iran great again. Trump previously said he's considering military options to support the Iranian people and warned the regime against killing protesters. However, the human rights activist news agency now says almost 2,000 demonstrators have been killed in more than 2 weeks of protests. Here's more on the situation in Iran.
President Donald Trump is ramping up pressure on Iran, which is facing its largest anti-government protests in years. On Monday, Trump announced that any nation doing business with Tehran will face a 25% tariff on U.S. trade. He called the order final and conclusive, but is yet to release further details. Iran, which already faces heavy U.S. sanctions, counts China, the United Arab Emirates, and India among its top trading partners. The protests in Iran began after soaring prices and economic hardship, but have since escalated into calls for the fall of the Iranian regime. The U.S. has warned its citizens in Tehran to consider leaving by land to Armenia or Turkey due to the protests. The situation has rattled global oil markets, pushing prices to 7-week highs on Monday due to fears of supply disruptions.
Staying in the Middle East, the Trump administration has designated 3 branches of the Muslim Brotherhood as terrorist groups. The Treasury and State Departments announced the actions today, affecting Muslim Brotherhood chapters in Lebanon, Jordan, and Egypt. The Trump administration said these organizations pose a risk to the U.S. and American interests. President Trump ordered the designation last month. The 3 branches and their members now face U.S. sanctions. Secretary of State Marco Rubio said in a statement, quote, "The United States will use all available tools to deprive these Muslim Brotherhood chapters of the resources to engage in or support terrorism." Jordan and Egypt have also banned the Muslim Brotherhood in their countries. Other U.S. allies in the region, such as Qatar and Turkey, are more tolerant of the organization. And the Trump administration is ending temporary protected status for thousands of Somalis in the United States. White House Press Secretary Caroline Leavitt says they'll be required to leave by March 17th.
It is corrupt, and it was under the leadership of Governor Walz and this mayor that they allowed.
In a statement to Fox News today, DHS Secretary Kristi Noem said, quote, "Temporary means temporary." She added that country conditions in Somalia have improved to the point that it no longer meets the law's requirement for temporary protected status. She also said allowing Somali nationals to remain temporarily in the U.S. is contrary to our national interests. Trump said in November that he was terminating deportation protections for Somalis living in Minnesota. The decision comes as federal authorities investigate reports of widespread fraud in the state. And an update on alleged widespread fraud in Minnesota. In an exclusive interview with Blaze TV, Treasury Secretary Scott Bessent says investigators have uncovered schemes far larger than expected, with illegally obtained taxpayer funds sent overseas. NTD's Daniel Monahan has the key takeaways from Bessent's interview with Blaze TV host Christopher Rufo.
Treasury Secretary Scott Bessent says Minnesota has become a blueprint for uncovering similar fraud nationwide.
The American people are the most generous people in the world. You just can't take advantage of us. When immigrants come here, you got to learn which side of the road to drive on, customs and laws to follow, and that you cannot steal from the U.S. government the way you did from your government.
Bessent says fraudsters have set up an organized scheme to game the system.
Benefits have been turned into businesses. It is a cottage industry of teaching people how to form multiple LLCs, how to game the system, how to move money around, and we'll see where the money goes.
The Treasury Secretary raised concerns about what he calls massive leakage of public assistance funds leaving the country.
If you are on public assistance and you were sending money out of the country, one of two things must be true. You were getting too much assistance because you have excess funds to feed yourself, your family, food, clothing, or you've got stolen money and you're sending that out. But in either case, money needs to stay in the U.S. or your benefits need to be cut.
Besson touched on potential cover-ups, saying there are evidently tapes of Attorney General Keith Ellison in meetings with people who donated to him.
Them calling for political favors to stop the investigations. So we'll see. But again, I don't want to get out ahead of the investigations. It's going to be very methodical. And Chris, I can guarantee you when the bear trap snaps, we're going to get these folks.
The Treasury Secretary says his interview was originally planned at the Minnesota State Capitol, but Governor Tim Walz refused to guarantee Besant would be provided any police security.
He is afraid of what is coming, and he's not going to be able to hide behind this curtain because we will get there, and I don't have to go in the Capitol building to investigate him. I would love for him to come to Treasury and answer some questions. I can guarantee you that he will be safe and sound then, depending on what we discover. I don't know about his future.
Besant also discussed an alleged bribery attempt.
One of the Somali fraudsters tried to bribe a juror with $120,000. Well, it turned out she'd been given $200,000 to bribe the juror, and she skimmed $80,000.
Besant further warned that protests obstructing federal law enforcement appear coordinated and funded.
Someone is financing them. There are safe houses that when you see the 300 people with the same laser that they're using to blind DHS agents in courthouses in Portland, someone bought those lasers. And again, what we do is follow the money.
The Treasury Secretary talked about all the luxury cars and properties bought from Minnesota to East Africa.
How the hell did this happen? How did it happen? Like, President Trump is outraged. I'm outraged. The American people should be outraged.
The Treasury has announced that IRS civil enforcement teams are auditing financial institutions suspected of facilitating the laundering of Minnesota fraud proceeds.
In addition, the IRS will soon launch a dedicated task force to work alongside criminal investigators and prosecutors to recover funds and prevent fraudulent nonprofits from exploiting federal programs. Daniel Monahan, NTD News.
Thank you, Daniel. And the Department of Homeland Security is facing legal challenges over immigration enforcement in Minnesota. The state is suing the Trump administration over ICE deployments. The lawsuit comes amid protests following the fatal shooting of a woman by an ICE agent. Here are the details.
Minnesota is suing the federal government over a surge in ICE agents to the Twin Cities. The state is calling it unconstitutional and unlawful. The lawsuit names Secretary Kristi Noem and alleges DHS is targeting Minnesota for political reasons.
We allege that the obvious targeting of Minnesota for our diversity, for our democracy, and our differences of opinion with the federal government is a violation of the Constitution and of federal law.
The department is pushing back, saying immigration and customs enforcement is federal law enforcement and belongs everywhere that federal law applies. Acting ICE Director Todd Lyons told Fox News yesterday that ICE is present in all 50 states, and law enforcement in states like Texas and Florida cooperate with ICE instead of opposing it.
If we have ICE agents or deportation officers that are being harassed and impeded, their state law enforcement and local law enforcement actually comes to the aid of ICE, not turn down our 911 calls, not show up to a protest. We only are increasing our numbers because ICE agents are getting attacked due to the lax policies that Minnesota has.
Lyons also said that Minnesota is a sanctuary state.
They don't honor our detainers, and they release criminals back into the neighborhood.
In a press release yesterday, DHS said ICE has removed child abusers, drug traffickers, and domestic violence perpetrators from Minnesota's streets. Assistant Secretary Tricia McLaughlin said the department will not let rioters or sanctuary politicians slow it down from arresting and removing the worst of the worst in Minnesota.
Illinois also unveiled a lawsuit yesterday. It accuses the administration of creating turmoil and imposing a climate of fear in the state and in the city of Chicago. Still to come, a landmark report lays out ways to stave off a decline in family life here in America. The Heritage Foundation's president joins us for insight. And a couple of Republican senators say they will block President Trump's Federal Reserve nominees. They're protesting the DOJ's investigation into Fed Chair Jerome Powell. President Trump denies knowledge of the investigation. Those stories and more after this.
All throughout your home, appliances and systems just wait for the worst time to break down and leave you with expensive repairs. Unless you have a plan from Choice Home Warranty.
All home appliances and systems have a breakdown clock, and when it expires, it will cost hundreds and potentially even thousands of dollars to fix or replace. That's why every homeowner should have a plan with Choice Home Warranty, like I do. For a low monthly fee, a Choice Home Warranty plan will cover your heating, air conditioning, plumbing, appliances, and more. Don't let an unexpected repair wreck your budget. With Choice Home Warranty, that covered repair is fixed or replaced for you.
Choice Home Warranty has been a great company to work with, and they've taken care of us. I would suggest anybody who lives in a home not to be in a home without him.
Avoid the ticking clock of home appliances and systems breaking down with a plan from Choice Home Warranty. Call now to get your first month free. Call in the next 10 minutes and we'll give you $120 off your first year of coverage. That's $200 in total savings.
With a nationwide network of over 25,000 technicians, I don't worry about how my next breakdown will be handled. With a click of a button, my claim is filed, and Choice Home Warranty starts the clock. They do the legwork, hiring the right technician and handling the cost of covered repairs and replacements. And check this out. For a limited time, you can get 1 month of coverage free. Did you hear me? Free. You can't beat that deal with a sledgehammer. But hurry, this offer is ticking away. Once the clock hits zero, poof, it's gone.
Don't fear the breakdown clock. Get a plan from Choice Home Warranty and get round-the-clock money-saving protection you can count on. Call in the next 10 minutes and we'll give you $120 off your first year of coverage, plus get your first month free. This offer won't last long.
Get your home protected. Call now.
Don't wait for an appliance or system to break down. Call before that happens. Call 800-983-3523. 800-983-3523.
August was born 3 pounds, 9.8 ounces. When I first saw him, it was like a whole range of emotions, joy, sadness. There's gonna be obstacles. You're gonna feel like, why is it happening to me? And you're gonna realize you're not the only one. There's no perfect way. Your own way will be the perfect way. You're gonna protect it with all your might. Just seeing him happy, it's just joy, you know? I look through his eyes, I can envision like a whole future with him already. To throw the first football to him, give him ice cream for the first time. Oh man, he could smile now. I'm happy because he's advancing in life, you know, he's growing. Being a young dad, it's not giving up, it's shifting. My life is now devoted to his life.
Welcome back. People just aren't starting families as much as they used to. And the ones that do have a rockier time than before. Where does that leave our hearts, our minds, and our nation? A new Heritage Foundation report delves into all that and offers some interesting ways to fix it. With us now is Dr. Kevin Roberts, president of the Heritage Foundation. Good to have you with us, Dr. Roberts.
Thanks so much. I'm so proud of my colleagues for issuing this landmark study. We hope that it revitalizes marriage and, for that matter, revitalizes the spirit of people welcoming children into their homes.
Certainly, it touches on a lot of things that are very meaningful to a lot of people. And to that point, there's this loneliness epidemic, according to the previous U.S. Surgeon General. People aren't having babies as much as they used to, as I just said. And even the prospect of a simple, straightforward path to old age surrounded by the people we love of all generations kind of seems to be slipping away from so many of us. So to start with, and this does come up in the report, how do you think we got here?
Well, there are certainly a lot of factors that have contributed to this problem. Some of them are cultural, some of them are social, and no doubt many of them are economic, to say nothing of individual decisions that people make, and we will always respect those individual decisions. But the real gist of the report, as you know, is that we claim that federal policy has exacerbated some of those factors by creating disincentives to marriage and, by extension, to having more children. We see that, for example, in our tax code. We see it in some safety net or welfare programs. And so the first step that we call for in the report is to eliminate all of those disincentives toward marriage. And then the second thing we call for, which is the real innovation in this study, is to flip on their head all of those programs within federal policy that have anything to do with marriage and make sure that through innovations in the child care tax credit and innovations in the usage of the adoption tax credit, that we can incentivize marriage and also childbirth.
And you also speak about the role of cultural institutions in reviving family life, if you'd like to touch on that.
It's a really important part of it. In fact, we would say that as important as it is to get federal policy right, that those cultural factors, those institutions, as you put it so well, are upstream, if you will, of the politics and policy of this. And so the most important of those cultural institutions, obviously, is the family. But our nuclear families are served by institutions like schools and universities and Rotary clubs and bowling leagues and so on. Very longstanding argument in the United States about the importance of those. And so we call for a role in federal policy there as well. For example, there has been a longstanding program of the federal government to fund what is called a marriage boot camp. That sounds sort of involuntary, but in fact, it's totally voluntary for couples that are not married but living together. We argue that one of the enhancements that federal policy could make is to turn that into a grant program, a block grant program, in which the people's tax money would be given to local nonprofit providers who would develop programs at the behest, at the request of these couples to learn how to be better couples. These are very simple innovations that the United States has overlooked in the realm of policy that could aid these cultural institutions.
Yeah, your report delves into so many aspects of how we got here, and some of the things that really stood out to me, for example, were that people are often choosing to have a standard family, but say without initially getting married. And the research that shows that that doesn't really put them in the best stead for the longevity of their life together and their family. So if you could speak to that. Yeah.
It's such an important point. Thank you for asking the question and for delving into that detail in the paper, because the best, least politicized social science research shows that there is a certain sequence which almost guarantees success in life. Graduating from high school, going to college, getting married, being open to life, having children. And the great part about our paper is that it rests upon this unpoliticized social science research. The second aspect of this is what people want. It is clear to us in analyzing this research and looking at public opinion surveys that while, of course, this is the United States and we respect people's decisions as individuals, the majority of American men and women do want to be married. They do want to be married and to have children. And so what we're saying is that it's high time that federal policy and state policy reflect these desires of the American people. In fact, that policy, as I have mentioned, not only doesn't reflect the desires of our people to be married and to have families, it's actually undermined those desires. So we have a lot of work to do in Washington to update this policy to reflect the mood of the American people. And I think what we will see is that when federal policymakers and state policymakers start making these decisions, that the cultural institutions will follow.
And I do want to dig into some of the key recommendations you have for Congress, but something else that really stood out to me was this talk in this very in-depth report about soulmates. And you say that in the report that the very idea of soulmates could actually be stopping some people from having happy, long-lived marriages. If you could speak to what the research shows that they can do to turn this around, this trend.
Yeah, there are some great studies by my colleagues at Heritage, but also by some great social scientists, again, across the political spectrum. And this actually connects to your point about your opening point about loneliness, that many Americans are desiring to be married, and they have this sort of platinum level standard about finding their soulmate. And I mean, I can tell you from personal experience that I didn't realize my wife was my soulmate until we were married for a few years. It didn't mean that we didn't want to get married. It didn't mean that we didn't enjoy each other's company. We didn't enjoy married life. But that's the kind of thing that takes time. And so what that social science research proves is what we intuit. In fact, what we emote as human beings. And we're saying that federal policy and state policy should reflect a reality that people know anecdotally, as I has related an anecdote about myself, but also one that we know sort of universally. And I think what we're going to see is as federal policymakers talk about this, given this permission, if you will, from this social science research, that leaders of cultural institutions, whether they be churches, whether they be leaders of schools or universities, are going to be part of this national conversation as well. And that all is going to help the dynamic that you put your finger on.
Well, there's a lot of deep and wide-ranging research outlined in this report, and I know all of that funnels into your varied and many recommendations for Congress, many solutions you put forward, and I wish we could speak longer, but that's all we have time for now. Thank you so much, Dr. Kevin Rubb. It's good to have you on.
We're so grateful for your interest. Thank you.
Next, Dilbert cartoonist Scott Adams has died after a battle with prostate cancer. He was 68 years old. Adams' ex-wife, Shelley, made the announcement today. Dilbert was a satirical comic strip that made fun of American office culture. The series ran from 1989 to 2023. Adams also hosted a live stream podcast entitled Real Coffee with Scott Adams. President Trump took to Truth Social today to express his condolences to Adams' family, friends, and listeners. Trump posted, quote, "Sadly, the great influencer Scott Adams has passed away. He was a fantastic guy who liked and respected me when it wasn't fashionable to do so." Trump added that Adams will be truly missed. And our thoughts go out to Adams' family as well. This morning, President Trump is again calling on Federal Reserve Chairman Jerome Powell to lower interest rates. This comes as some lawmakers on Capitol Hill are expressing concern over a new DOJ investigation related to the chairman. A couple of senators are blocking President Trump's Federal Reserve nominees.
Republican senators, including Elisa Murkowski and Tom Tillis, are questioning the authenticity of an investigation into Chairman Jerome Powell. Now, in a bid to urge officials to quickly resolve the case, these senators are vowing to block President Trump's Federal Reserve nominees.
I very seldom disagree with the president, but I've disagreed with bad advice he's been given and acted on.
President Trump has denied knowledge of the investigation, though he previously threatened legal action against Powell, accusing him of incompetence. Senator Murkowski, the latest, joined Senator Tillis in ramping up the pressure around this investigation, raised concerns about the fact that this investigation revolves around project cost overruns, which she says are not unusual. This Department of Justice investigation started over concerns about Powell's handling of the renovation at the Federal Reserve's headquarters. Specifically, investigators are looking into whether Powell committed perjury when he testified to a Senate committee about the project last year. The project is over budget. It was originally approved for $1.9 billion, but now it's costing around $2.5 billion of taxpayer money. The Fed's inspector said that this increase in the price is due to the timeline extension and material costs. The White House Economic Council director yesterday told reporters at the White House that even if cost overruns on projects aren't out of the ordinary, it's still important to know where taxpayer money goes.
Seems like the Justice Department has decided that they want to see what's going on over there with this building that's, massively more expensive than any building in the history of Washington. I think that it's really important to understand where the taxpayer money goes.
Chairman Powell was quick to deny the allegations of the lawsuit and said that the Trump administration only launched it because he refused to lower interest rates to a level that President Trump is happy with.
The threat of criminal charges is a consequence of the Federal Reserve setting interest rates based on our best assessment of what will serve the public, rather than following the preferences of the president.
While some Republicans aren't comfortable with this investigation, others say it's serious and warranted. Speaker Johnson today doubling down on his previous comments.
If there's a credible allegation or concern that someone's lied to Congress, then the DOJ should investigate. I mean, across the board, no matter who it is, no one is immune from that.
Chairman Powell will be replaced in just a few months as he reaches the end of his term in May. Reporting from Washington, D.C., Melina Weisskopf, NTD News.
A New York City Council employee was detained by ICE during a routine immigration appointment on Long Island yesterday. The Department of Homeland Security says he was there illegally and did not have work authorization. Council Speaker Julie Menon said the employee, a Venezuelan national, works as a data analyst and has a work visa. She called the detainment government overreach. DHS Assistant Secretary Tricia McLaughlin disputed those remarks and said he has a criminal record, including for assault. In a post on X, New York City Mayor Zohran Mamdani called the arrest an assault on democracy, on New York City, and on our values. He called for the employee's release and said he would continue to monitor the situation. Treasury Secretary Scott Bessent held a meeting of finance ministers from G7 countries and other major economies yesterday. The agenda included discussing ways to secure and diversify supply chains for critical minerals, especially rare earth elements.
So in this meeting, participants from various countries, they discussed their experience, the steps that they are taking in making the supply chain resilient, especially technology for refining, processing the mineral ores so that high quality critical minerals, especially the rare earth, permanent magnets, those kind of materials can be secured in a long term, in a sustainable manner.
The meeting was attended by G7 members, including Canada, Germany, and Japan. Representatives from Australia, India, Mexico, and South Korea were also there. One topic was reducing reliance on China for critical minerals. China often uses its position in the rare earth market to negotiate deals and has imposed strict controls on rare earth exports. Representatives also discussed funding for new projects to support sustainable extraction and processing. And the Transportation Department says new regulatory changes could save Americans about $600 million a year while maintaining safety standards. Transportation Secretary Sean Duffy announced the reforms yesterday. He's directing the Pipeline and Hazardous Materials Safety Administration to modernize decades-old rules. One change updates pipeline regulations to reflect advances in technology. It allows operators to avoid unnecessary replacements and save more than $460 million annually. Another rule cuts compliance costs for transporting fuel by cargo tank, generating an additional $145 million in savings. The department is also easing compliance enforcement in regions affected by the national energy emergency, aiming to lower energy costs for families while prioritizing safety. And the Supreme Court today began hearing oral arguments in 2 cases over transgender sports. The justices will consider the legality of state laws banning men from women's sports. Idaho and West Virginia have imposed such laws but faced legal challenges. They're appealing to the High Court to overturn lower courts' decisions that sided with their challengers. Supporters of the bans, including the Trump administration, argue they protect women's sports, while opponents argue the bans discriminate against people who identify as transgender.
Idaho's law classifies on the basis of sex because sex is what matters in sports. It correlates strongly with countless athletic advantages like size, muscle mass, bone mass, and heart and lung capacity. Tragically, but not surprisingly, male athletes have even injured female athletes in many sports. If women don't have their own competitions, they won't be able to compete. Gender identity does not matter in sports, and that's why Idaho's law does not classify on the basis of gender identity. It treats all males equally and all females equally, regardless of identity, and its purpose is exactly what the legislature said: preserving women's equal opportunity. In fact, it's our friends on the other side who want to classify based on gender identity. They're seeking special treatment for males who allegedly lack an unfair advantage, but only if those males also identify as transgender. Denying special treatment isn't classifying on the basis of transgender status. It's consciously choosing not to.
That means HB 500 is aimed at controlling for sex-based biological advantages, not for all of the many reasons one athlete may be better than another that have nothing to do with sex. On the preliminary record in this case, and as the experts below agreed, circulating testosterone after puberty is the main determinant of sex-based biological advantage that HB 500 sought to address. And on this record, Lindsay Hecox has mitigated that advantage because she has suppressed her testosterone for over a year and taken estrogen. HB 500 thus fails heightened scrutiny as applied to Lindsay and transgender women like her who have no sex-based biological advantage as compared to birth-sex females. That analysis would come out the other way for the untalented cisgender boy. He would have the same sex-based advantage, the circulating testosterone, he just would not be as good at sports. It also would come out the other way here, for example, if a transgender woman had gone through a male puberty and had not mitigated that advantage.
For analysis, we welcome Anastasia Bowden, civil rights attorney at Pacific Legal Foundation and SCOTUS blog columnist. Good to have you with us today, Anastasia.
Thanks for having me.
Now, plaintiffs are arguing that these state-level bans on boys participating in girls' sports violates the 14th Amendment. Looking at the arguments so far, which points stand out to you as strongest?
Yeah, I think the justices are really concerned with the reach of each side's arguments. So here, the challengers are saying they're really focusing on not just a broad ban, but the fact that there might be some transgender women who have mitigated their advantages. For example, by reducing their level of testosterone. And the justices are saying, okay, well, if the state requires an exception for you, then can it require exceptions for men, not even transgender women, but just men who can't compete in their own sports because they don't enjoy the same physical advantages as typical males? You know, they're shorter, they happen to have less testosterone. How many exceptions do we have to allow, and how many men do we have to allow to compete in women's sports? On the other side of the ledger, we have justices asking about the limits of that side's arguments. So the states here argue that we need to separate men and women in sports because men and women are different. And the justices are probing, well, what about certain classes? We know that men and women perform differently in certain subjects. Does that now allow states to require separate classes for them, or only remedial measures for men if they perform not as well as women on certain subjects, and women can be excluded from those subjects? So it's very interesting to see the justices not just focus on the arguments at hand, but the reach of both sides' arguments.
Yeah, and based on what you've seen, how do you think the Supreme Court might rule, and why?
I think it almost certainly will rule in favor of the states here. We know from last term that the justices are skeptical that these laws that purportedly discriminate on the basis of transgender status discriminate based on sex. They say, no, this is different. Discriminating against transgender people is not sex-based discrimination. And so, you know, Justice Barrett also indicated last term that even if we think that these laws discriminate against transgender people, that doesn't entitle them to any heightened protection, because historically transgender people haven't been subject to legal discrimination. So we're not going to treat them different or give them more protection under the Equal Protection Clause. That concurrence that she wrote was not binding, but it's a pretty good indicator of where the court's head is at. So I think they're going to say that the state has a good enough interest here to protect women in women's sports. Transgender people do not get any special protection, and they're going to defer to the state to allow the state to protect women as they wish.
If the states win, what will that all mean for women and girls sports across the country?
Well, it doesn't mean that men and women must be separate in sports. 23 states allow transgender women to play in women's sports. It just means that those states, those 27 states who choose to act and protect women in women's sports, may do so constitutionally and legally under our civil rights laws. So it allows states to act, but it doesn't require states to act any one way. And I think, you know, all of this is borne out. You're asking me, how can we read the tea leaves here? One indication of how we can read it is the cover of Washington Post today, which says, neither science nor public opinion supports the challengers in this case. I mean, wow, what the tide has really turned here. And I think that public change of opinion is definitely going to be influential in the way that the court rules.
Yeah, fascinating. Some are arguing that privacy and safety are actually at stake here in this case. How much do you think those concerns might influence the justices?
Well, it's really interesting because typically we think of privacy and safety on behalf of the women who do not want people who were born male in the locker room. I think it's interesting to see the challengers here sort of weaponize or change that argument when we're talking about, some people have said, well, if we allow exceptions for trans women who have lower testosterone, then you're going to invade their privacy by forcing them to be subject to constant monitoring and testosterone testing, which can be very invasive, requires blood tests and hormone tests and all these things. And so it's interesting to see both sides invoke this interest in privacy. But ultimately, I think the most salient thing, the things from oral argument, the arguments that hit the most were the ones that come to people from a commonsensical point of view. I mean, where do we really think the privacy concerns lie? They lie with the women who want to be safe in their locker rooms. And so ultimately, I think those are the types of arguments, the common sense ones, that are going to win the day.
And this whole case really comes to the heart of something that's been an ongoing discussion within U.S. society and culture in recent years. Is there anything missing from the discussion at this point that you think needs to be highlighted more? Just to finish.
Yeah, well, I think it's interesting that the challengers have talked about, well, science is evolving. We don't really know about what gives trans women advantage in women's sports. And so we shouldn't allow the state to act so bluntly. But in reality, if science is evolving, you'd think the answer would be to defer to the states and to allow them to tackle this problem as it comes and to protect women as they see best. And so ultimately, again, I just think that's common sense to people. I think it's the pulse of public opinion. And it's the reason that the court is going to come down in the state's favor.
Well, great to hear your insights today. Thank you so much for your time, Anastasia Bowden.
Thanks for having me.
And coming up, Denmark and Greenland's foreign ministers are meeting with J.D. Vance and Marco Rubio. Their meeting comes as President Trump pushes to acquire the Arctic island. And the BBC files a motion to dismiss President Trump's defamation lawsuit. The president is suing the British broadcaster for splicing footage of a speech he gave on January 6, 2021. Those stories after this.
I'm Jonathan Lawson. If you're 50 to 85, please listen closely. The lock I want to talk to you about isn't the one on your door. It's a rate lock for your life insurance that guarantees that once you're insured, your rate can never go up at any time for any reason. Many policies you see don't have one, but you can get a lifetime rate lock from Colonial Penn. This plan was designed for people on a fixed income with coverage options that start at $9.95 a month. That's less than 35 cents a day. Your rate is locked in for life. Coverage can never be canceled, and your acceptance is guaranteed. You cannot be turned down because of your health. See for yourself. Call for an information kit and gift. Both are free with no obligation.
Call 1-800-624-6556 for your free information and your free gift. That's 1-800-624-6556. 1-800-624-6556. Call now.
According to ancient Chinese medicine, purslane is considered a medicinal herb and is used to help lower cholesterol, improve vascular functions, and prevent diabetes. Perilla seeds can nourish the lungs and spleen. It is used to treat asthma and improve pulmonary functions. Puritang green vegetable omega-3 is made from purslane and perilla seeds from Hwangmae Mountain in South Korea. It contains over 90% of omega-3, 6, 7, and 9. The highest concentration possible without chemical additives. The soft gel is made of natural seaweed. It is 100% organic and vegan. Both adults and children can take it with peace of mind. Ancient recipes were passed down from heaven to bring prosperity and longevity. Puritang green vegetable omega-3.
On streets across America, homeless young people are cold, abused, in danger. Covenant House is helping young people with nowhere else to turn. Please call or go online now with your gift of $19 a month. You'll help provide hot meals, safe shelter, medical care, and love. We'll send you this comforting blanket as a reminder of the love you're showing a young person this holiday season. Call or go online now to safeplacetosleep.org, and your first month's gift will be matched.
I'm Stephanie Cox, and this is World Watch. The foreign ministers of Denmark and Greenland are expected to meet with Vice President J.D. Vance and Secretary of State Marco Rubio. Today's face-to-face meeting comes amid President Trump's push to take control of the Arctic island. The two foreign ministers requested the meeting. Trump first floated the idea of U.S. control over Greenland in 2019 during his first term. He says U.S. control of the Danish territory is necessary to counter threats from Russia and China. Denmark's defense minister said he would participate in a meeting with NATO's Secretary General in Brussels next week. Greenland's foreign minister is expected to attend that meeting as well. And the BBC has filed a motion to dismiss President Trump's $10 billion lawsuit. The president is suing the British broadcaster for editing his speech from January 6, 2021. Trump contends that the BBC defamed him after it combined separate parts of his speech that were 50 minutes apart. As a result, the splicing of the footage made it appear that he had directed supporters to storm the U.S. Capitol. The segment omitted a section in which Trump called for peaceful protest. The BBC argued that the court in Florida lacked jurisdiction because it did not broadcast the program in Florida. The organization also said the president can't prove damages because he was re-elected after the segment aired. French farmers drove around 350 tractors through Paris toward Parliament today to protest an EU trade deal with South America. The demonstrators say the agreement threatens their livelihood. French President Emmanuel Macron and his government oppose the deal. However, the agreement is expected to be signed in Paraguay Saturday because it has the support of most other EU countries. A number of European farmers have long denounced the trade deal with Brazil, Argentina, Bolivia, Paraguay, and Uruguay. They argue the move will flood the market with cheaper imports. A visiting member of Canada's parliament acknowledged Chinese aggression toward Taiwan today ahead of Prime Minister Mark Carney's visit to China. The Canadian lawmaker pushed for diplomacy while in the Taiwanese capital, Taipei.
We reject the normalization of intimidation, of military coercion, of attempts to rewrite international norms through force. We believe that resilience, economic, institutional, and societal, is built through strong partnerships, also grounded in freedom, in democracy, in the rule of law, and in human rights.
Canada has no official diplomatic ties with Taiwan. However, it does have many different economic relations with Taiwan. Now, the relationship between the two countries has deepened as China ramps up military threats against the democratic island. Two lawmakers from Carney's Liberal Party ended a visit to Taiwan early this week, citing advice from the Canadian government. Carney is expected to discuss trade and international security during his trip to China. New concerns over a cover-up linking the Chinese Communist Party with live organ harvesting may have surfaced. Last week, 2 screenshots from a chat group went viral on Chinese social media before they were censored. The content in the chat has alarmed many Chinese citizens. If true, it would be the latest indication that Chinese police and hospitals are conducting operations targeting people on the streets for organ harvesting. NTD's Flora Hua has that story.
The 2 screenshots quickly went viral after the author posted them on China's version of TikTok, Douyin, on Monday. After translating the messages into English, we dubbed the conversation for listeners.
She's buying durian at the fruit stand.
Tell XYZ and the others that once she finishes the purchase, they should detain her inside the apartment building and forcibly bring her back directly in an ambulance. Don't let her go home at all.
Okay.
Judging by her physique, her body fat percentage is likely high.
You guys want to take her?
Sure, the DNA anti-rejection tests have passed. Jilin University now has liver and kidney recipients.
Has the local police station been contacted?
I just finished contacting them.
When asked whether this means local police were involved in kidnapping the woman, the post author replied with a confirmation. What's more, the reference to Jilin University in the chat likely points to one of the university's 2 affiliated hospitals. A US-based human rights group that has investigated China's transplant industry for decades has listed both hospitals as highly suspected of engaging in large-scale live organ harvesting. The group was the first one to report that Falun Gong practitioners in China have been the primary target for their organs. The Chinese Communist Party has been brutally persecuting the faith group since 1999. But in recent years, the scale of organ harvesting victims appears to have grown, with increasing media reports of young people going missing in China. Now, both the screenshots and the whistleblower's Douyin account have been completely removed from the platform by Chinese regulators. The censorship has only made the claims more convincing to many, but the story has still left digital footprints. Search records on the platform, such as "What happened to the woman kidnapped?" show that many users tried to learn the fate of the woman mentioned in the chat. Flora Hua, NTD News.
Great report there from Flora Hua. Next, Elon Musk's X is facing growing scrutiny after reports that its AI chatbot Grok was used to generate non-consensual sexualized images of women and children. Several countries have taken action, with regulators investigating or blocking access to the tool. NTD's Christina Corona tells us more.
The UK's media regulator, Ofcom, has launched an investigation into Elon Musk's Grok AI chatbot following reports that the tool was used to create sexually explicit deepfake images, including those involving minors. The British government is set to enforce a new law this week that criminalizes creating sexual deepfakes, calling the content a form of online abuse.
The Internet Watch Foundation reports criminal imagery of children as young as 11, including girls sexualized and topless. This is child sexual abuse.
Kendall says reports show images of women in bikinis as well as in abusive and disturbing situations. UK Prime Minister Keir Starmer has called the images disgusting and unlawful.
Lives can and have been devastated by this content, which is designed to harass, torment, and violate people's dignity.
European Union officials have also condemned the platform, warning tech companies they will act if users are not protected. They say regulators can take action and issue fines if rules aren't followed.
They can investigate the service, they can issue enforcement action, and if that enforcement action is not complied with, they can fine the platform £18 million or 10% of their worldwide revenue, whichever is greater.
Southeast Asian countries are also taking action. Indonesia and Malaysia have temporarily blocked access to Grok, citing risks to women, children, and public safety. However, Elon Musk has responded, saying X removes the illegal content, stating, "We take action against illegal content on X, including child sexual abuse material, by removing it permanently, suspending accounts, and working with local governments and law enforcement as necessary." He goes on to say, anyone using or prompting Grok to make illegal content will suffer the same consequences as if they upload illegal content. Musk made almost exactly the same statement on January 3rd. Christina Corona, NTD News.
And President Trump is traveling to Michigan today with stops planned in Detroit and Dearborn as he highlights manufacturing and economic priorities. The president is set to address the Detroit Economic Club during an event at Motor City Casino. The club says it will be Trump's third address there. On the campaign trail in 2024, he joined a list of speakers, including former Presidents Jimmy Carter, Ronald Reagan, Bill Clinton, and Bush's Sr. and Jr. Trump will also tour Ford Motor Company's historic Rouge Center, where the automaker builds its F-Series trucks. Ford says the visit will showcase American workers putting the automobile within reach of every American. Trump was last in Michigan in April 2025 to celebrate the first 100 days of his second term. Here's the president speaking to reporters before departing the White House earlier. Take a listen.
We're going to Detroit. We'll be talking about how well the economy is doing. As you know, the inflation numbers just came out, and we have very low inflation, so that would give Tulane Powell the chance to give us a nice, beautiful, big rate cut, which would be great for the country, but rates are falling also, and growth is going up. We have tremendous growth numbers, so growth is going up. So I'll be talking about that today in Detroit. It's a big speech, and I can only say that the country is doing well.
The Supreme Court today began hearing oral arguments in 2 cases over transgender sports. The justices will consider the legality of state laws banning men from women's sports. Idaho and West Virginia have imposed such laws, but face legal challenges. They're appealing to the High Court to overturn lower courts' decisions that sided with their challengers. Supporters of the bans, including the Trump administration, argue they protect women's sports, while opponents argue the bans discriminate against people who identify as transgender.
Idaho's law classifies on the basis of sex because sex is what matters in sports. It correlates strongly with countless athletic advantages like size, muscle mass, bone mass, and heart and lung capacity. Tragically, but not surprisingly, male athletes have even injured female athletes in many sports. If women don't have their own competitions, they won't be able to compete. Gender identity does not matter in sports, and that's why Idaho's law does not classify on the basis of gender identity. It treats all males equally and all females equally, regardless of identity, and its purpose is exactly what the legislature said: preserving women's equal opportunity. In fact, it's our friends on the other side who want to classify based on gender identity. They're seeking special treatment for males who allegedly lack an unfair advantage, but only if those males also identify as transgender. Denying special treatment isn't classifying on the basis of transgender status. It's consciously choosing not to.
That means HB 500 is aimed at controlling for sex-based biological advantages, not for all of the many reasons one athlete may be better than another that have nothing to do with sex. On the preliminary record in this case, and as the experts below agreed, circulating testosterone after puberty is the main determinant of sex-based biological advantage that HB 500 sought to address. And on this record, Lindsay Hecox has mitigated that advantage because she has suppressed her testosterone for over a year and taken estrogen. HB 500 thus fails heightened scrutiny as applied to Lindsay and transgender women like her who have no sex-based biological advantage as compared to birth sex females. That analysis would come out the other way for the untalented cisgender boy. He would have the same sex-based advantage, the circulating testosterone, he just would not be as good at sports. It also would come out the other way here, for example, if a transgender woman had gone through a male puberty and had not mitigated that advantage.
As the U.S. Supreme Court hears arguments in blockbuster cases challenging transgender sports bans, House Speaker Mike Johnson showed his support outside the Supreme Court.
I'm the dad of 2 girls. My girls were athletes as well. We know what's fair and what's right. I'm proud to stand with you as we fight to protect female-only spaces and sports, and truly the future of women's athletics. Every Republican here in this House is with you. We stand in solidarity with you, and you know that. And every young woman and girl has the right to compete safely and fairly.
And that's all we have time for this hour, but if you have any feedback on the show or have something you'd like to see us cover, send us an email at news.today@ntd.com. We'd love to hear from you. We'll cover more news right after this break.
Now's the time to save during the annual clearance event at Mathis Home. We have over 100 dining sets in stock with the styles you'll love. Values like this are hard to find. Take your pick. These modern dining sets are just $3.99. This one features a wood grain finish and 4 upholstered side chairs. This set has a durable faux marble top and 4 side chairs. Your choice, just $3.99 with fast, free delivery. Come save with the annual clearance event at your furniture superstore, Mathis Home.
Shenyun Creations, the streaming platform from Shenyun, featuring world-class dance, past programs, and all original music. Masterclasses, behind the scenes, comedy, and more. Explore shenyuncreations.com.
I go by Jackie. I'm 44 years old. I had 3 kids at the time and single mother. I was working 60 hours a week. Still couldn't pay the bills. Skipped meals so that they could eat. It's been hard because one thing falls into place, 10 things fall out of place. You know, I just can't do this alone and make it work.
1 in 5 children face hunger in America, and food costs are rising. But everyone needs nourishing food to thrive, and they can when we work together so our neighbors can feed their families. Call or go online right now to join Feeding America with your gift of just $19 a month, only 63 cents a day. Together, thanks to a nationwide network of food banks, dedicated volunteers, and the monthly support of people like you, we can fill plates with nutritious food for families across America.
One day my mother came over to my house and said, "There's a meeting at the pantry." I said, "Okay." And I went. There were some ladies in there. They were from the food bank. They asked several questions. Some of those were about me and my story, but it helped me to open up a little bit.
We're getting closer to the day when no one in America faces hunger, but we can't do it without you. Call or go online now. Visit helpfeedingamerica.org and give $19 a month, just 63 cents a day. 98% of donations go directly to help millions of people facing hunger, from coast to coast and in your own community. And when you give by credit card, we'll send you this exclusive canvas grocery bag to show you are a part of a movement of supporters working together to help end hunger.
I have people that I can trust. I have hope.
Please call now or make your monthly donation at helpfeedingamerica.org, and your gift can double in impact.
Welcome to NTD News Today. Here are today's top stories. President Trump is visiting Detroit today to refocus attention on U.S. manufacturing and his efforts to tackle high consumer costs. What we know about his schedule. The Supreme Court today faces a decision that could reshape women's athletics nationwide. The Trump administration ends temporary protected status for Somalis. The decision comes as Minnesota faces a widespread fraud scandal. The House Oversight Committee said it will seek to hold former President Bill Clinton in contempt of Congress. That's after the former president and his wife Hillary Clinton refused to testify in the House's Jeffrey Epstein investigation.
This is NTD News Today, live from our global headquarters in New York City.
Today is Tuesday, January 13th. I'm Victoria White. President Trump is traveling to Michigan today with stops planned in Detroit and Dearborn as he highlights manufacturing and economic priorities. The president is set to address the Detroit Economic Club during an event at Motor City Casino. The club says it will be Trump's third address there. On the campaign trail in 2024, he joined a list of speakers including former presidents Jimmy Carter, Ronald Reagan, Bill Clinton, and Bush's senior and junior. Trump will also tour Ford Motor Company's historic Rouge Center, where the automaker builds its F-Series trucks. Ford says the visit will showcase American workers putting the automobile within reach of the every American. Trump was last in Michigan in April 2025 to celebrate the first 100 days of his second term. Here's the president speaking to reporters before departing the White House earlier. Take a listen.
We're going to Detroit. We'll be talking about how well the economy is doing. As you know, the inflation numbers just came out, and we have very low inflation. So that would give Tulane Powell the chance to give us a nice, beautiful, big rate cut, which would be great for the country. But rates are falling also, and growth is going up. We have tremendous growth numbers So growth is going up. So I'll be talking about that today in Detroit. It's a big speech. And I can only say that the country's doing well.
And over to the Middle East, the Trump administration has designated 3 branches of the Muslim Brotherhood as terrorist groups. The Treasury and State Departments announced the actions today, affecting Muslim Brotherhood chapters in Lebanon, Jordan and Egypt. The Trump administration said these organizations pose a risk to the US and American interests. President Trump ordered the designation last month. The 3 branches and their members now face US sanctions. Secretary of State Marco Rubio said in a statement, quote, "The United States will use all available tools to deprive these Muslim Brotherhood chapters of the resources to engage in or support terrorism." Jordan and Egypt have also banned the Muslim Brotherhood in their countries. Other US allies in the region, such as Qatar and Turkey, are more tolerant of the organization. The Trump administration is ending temporary protected status for thousands of Somalis in the United States. White House Press Secretary Caroline Leavitt says they'll be required to leave by March 17th. In a statement to Fox News today, DHS Secretary Kristi Noem said, quote, "Temporary means temporary." She added that country conditions in Somalia have improved to the point that it no longer meets the law's requirement for temporary protected status. She also said allowing Somali nationals to remain temporarily in the US is contrary to our national interests. Trump said in November that he was terminating deportation protections for Somalis living in Minnesota. The decision comes as federal authorities investigate reports of widespread fraud in the state. And an update on alleged widespread fraud in Minnesota. In an exclusive interview with Blaze TV, Treasury Secretary Scott Bessent says investigators have uncovered schemes far larger than expected, with illegally obtained taxpayer funds sent overseas. NTD's Daniel Monahan has the key takeaways from Bessent's interview with Blaze TV host Christopher Rufo.
Treasury Secretary Scott Bessent says Minnesota has become a blueprint for uncovering similar fraud nationwide.
The American people are the most generous people in the world. You just can't take advantage of us. When immigrants come here, you got to learn which side of the road to drive on, customs and laws to follow, and that you cannot steal from the U.S. government the way you did from your government.
Bessent says fraudsters have set up an organized scheme to game the system.
Benefits have been turned into businesses. It is a cottage industry of teaching people how to form multiple LLCs, how to game the system, how to move money around, and we'll see where the money goes.
The Treasury Secretary raised concerns about what he calls massive leakage of public assistance funds leaving the country.
If you are on public assistance and you are sending money out of the country, one of 2 things must be true. You are getting too much assistance because you have excess funds to feed yourself, your family, food, clothing, or you've got stolen money and you're sending that out. But in either case, money needs to stay in the U.S. or your benefits need to be cut.
Bessent touched on potential cover-ups, saying there are evidently tapes of Attorney General Keith Ellison in meetings with people who donated to him.
Them calling for political favors to stop the investigations. So we'll see. But again, I don't want to get out ahead of the investigations. It's going to be very methodical. And Chris, I can guarantee you when the bear trap snaps, we're going to get these folks.
The Treasury Secretary says his interview was originally planned at the Minnesota State Capitol, but Governor Tim Walz refused to guarantee Bessent would be provided any police security.
He is afraid of what is coming, and he's not going to be able to hide behind this curtain because we will get there, and I don't have to go in the Capitol building to investigate him. I would love for him to come to Treasury and answer some questions. I can guarantee you that he will be safe and sound then, depending on what we discover. I don't know about his future.
Bessent also discussed an alleged bribery attempt.
One of the Somali fraudsters tried to bribe a juror with $120,000. Well, it turned out she'd been given $200,000 to bribe the juror, and she skimmed $80,000.
Besant further warned that protests obstructing federal law enforcement appear coordinated and funded.
Someone is financing them. There are safe houses that when you see the 300 people with the same laser that they're using to blind DHS agents in courthouses in Portland, someone bought those lasers. And again, what we do is follow the money.
The Treasury Secretary talked about all the luxury cars and properties bought from Minnesota to East Africa.
How the hell did this happen? How did it happen? Like, President Trump is outraged. I'm outraged. The American people should be outraged.
The Treasury has announced that IRS civil enforcement teams are auditing financial institutions suspected of facilitating the laundering of Minnesota fraud proceeds. In addition, the IRS will soon launch a dedicated task force to work alongside criminal investigators and prosecutors to recover funds and prevent fraudulent nonprofits from exploiting federal programs. Daniel Monahan, NTD News.
The Department of Homeland Security is facing legal challenges over immigration enforcement in Minnesota. The state is suing the Trump administration over ICE deployments. The lawsuit comes amid protests following the fatal shooting of a woman by an ICE agent. Here are the details.
Minnesota is suing the federal government over a surge in ICE agents to the Twin Cities. The state is calling it unconstitutional and unlawful. The lawsuit names Secretary Kristi Noem and alleges DHS is targeting Minnesota for political reasons.
We allege that the obvious targeting of Minnesota for our diversity, for our democracy, and our differences of opinion with the federal government is a violation of the Constitution and of federal law.
The department is pushing back, saying immigration and customs enforcement is federal law enforcement and belongs everywhere that federal law applies. Acting ICE Director Todd Lyons told Fox News yesterday that ICE is present in all 50 states, and law enforcement in states like Texas and Florida cooperate with ICE instead of opposing it.
If we have ICE agents or deportation officers that are being harassed and impeded, their state law enforcement and local law enforcement actually comes to the aid of ICE, not turn down our 911 calls, not show up to a protest. We only are increasing our numbers because ICE agents are getting attacked due to the lax policies that Minnesota has.
Lyons also said that Minnesota is a sanctuary state.
They don't honor our detainers, and they release criminals back into the neighborhood.
In a press release yesterday, DHS said ICE has removed child abusers, drug traffickers, and domestic violence perpetrators from Minnesota's streets. Assistant Secretary Tricia McLaughlin said the department will not let rioters or sanctuary politicians slow it down from arresting and removing the worst of the worst in Minnesota.
Illinois also unveiled a lawsuit yesterday. It accuses the administration of creating turmoil and imposing a climate of fear in the state and in the city of Chicago. A New York City Council employee was detained by ICE during a routine immigration appointment on Long Island yesterday. The Department of Homeland Security says he was there illegally and did not have work authorization. Council Speaker Julie Menin said the employee, a Venezuelan national, works as a data analyst and has a work visa. She called the detainment government overreach. DHS Assistant Secretary Tricia McLaughlin disputed these remarks and said he has a criminal record, including for assault. In a post on X, a New York City Mayor Zoran Mamdani called the arrest an assault on democracy, on New York City and our values. He called for the employee's release and said he would continue to monitor the situation. The Supreme Court today faces a decision that could reshape women's athletics nationwide. It's coming up.
Hi, I'm Susan Lucci. You may know me from my many years on television. I never thought about heart disease until I had my own heart event. I felt this slight pressure on my chest, just slight. I thought, oh, it's nothing, it'll go away. I didn't get it. I did not get it. But a few days later, while shopping at a boutique, that pressure returned, much stronger. It felt like an elephant pressing on my chest. I had a 90% blockage in my main artery and a 75% blockage in the adjacent artery. I was rushed into surgery where I received 2 stents in my arteries. stents developed through research funded by the American Heart Association. Those stents saved my life. That's why I'm in front of you today, asking you to join me in supporting the American Heart Association by becoming a monthly donor. Call now or go to helpheart.org. For only $19 a month, just 63 cents a day, you can help fund the next medical breakthrough. Get the next person trained in CPR, the next hospital certified in high-quality cardiovascular care. I'm so grateful to the American Heart Association. Their research helped save my life. I can enjoy life with my children, my grandchildren, and my friends. Heart disease is America's #1 killer, and your support now can help save your life or the life of someone you love. Give $19 a month with your credit card, and we'll send you this special t-shirt that you can wear to show that you are helping save lives. Please, listen to your heart. The only reason I'm here today is because I did. So please call the number on your screen or go to helpheart.org now. Join me as a monthly donor today and help save even more lives. Thank you.
My name's Stacy, I'm 57, and I was adopted in 2020.
We were adopted in 2019.
And we were adopted in 2021.
We had a house, and it sounds crazy, but it wasn't a home. The one thing that Jake and Emma brought is it became a home.
When I met Dakota, he had just turned 14.
You weren't there for the first this and the first that. I missed the first words, but we got a lot of other firsts.
Watching her say, oh my God, I cannot believe I got my license. And she's like, I passed. And I'm like, girl.
See them grow. It is.
They chose to love us. They didn't have to. They chose us. Family.
You and you.
Kids in the middle.
What I thought was a complete life was nowhere near complete, but it is now.
Learn about adopting a teen from foster care. You can't imagine the reward. Visit adoptuskids.org.
The Supreme Court today began hearing oral arguments in 2 cases over transgender sports. The justices will consider the legality of state laws banning men from women's sports. Idaho and West Virginia have imposed such laws but faced legal challenges. They're appealing to the High Court to overturn lower courts' decisions that sided with their challengers. Supporters of the bans, including the Trump administration, argue they protect women's sports, while opponents argue the bans discriminate against people who identify as transgender.
Idaho's law classifies on the basis of sex because sex is what matters in sports. It correlates strongly with countless athletic advantages like size, muscle mass, bone mass, and heart and lung capacity. Tragically, but not surprisingly, male athletes have even injured female athletes in many sports. If women don't have their own competitions, they won't be able to compete. Gender identity does not matter in sports, and that's why Idaho's law does not classify on the basis of gender identity. It treats all males equally and all females equally, regardless of identity, and its purpose is exactly what the legislature said: preserving women's equal opportunity. In fact, it's our friends on the other side who want to classify based on gender identity. They're seeking special treatment for males who allegedly lack an unfair advantage, but only if those males also identify as transgender. Denying special treatment isn't classifying on the basis of transgender status. It's consciously choosing not to.
That means HB 500 is aimed at controlling for sex-based biological advantages, not for all of the many reasons one athlete may be better than another that have nothing to do with sex. On the preliminary record in this case, and as the experts below agreed, circulating testosterone after puberty is the main determinant of sex-based biological advantage that HB 500 sought to address. And on this record, Lindsay Hecox has mitigated that advantage because she has suppressed her testosterone for over a year and taken estrogen. HB 500 thus fails heightened scrutiny as applied to Lindsay and transgender women like her who have no sex-based biological advantage as compared to birth sex females. That analysis would come out the other way for the untalented cisgender boy. He would have the same sex-based advantage, the circulating testosterone, he just would not be as good at sports. It also would come out the other way here, for example, if a transgender woman had gone through a male puberty and had not mitigated that advantage.
As the US Supreme Court hears arguments in blockbuster cases challenging transgender sports bans, House Speaker Mike Johnson showed his support outside the Supreme Court.
I'm the dad of 2 girls. My girls were athletes as well. We know what's fair and what's right. I'm proud to stand with you as we fight to protect female-only spaces and sports, and truly the future of women's athletics. Every Republican here in this House is with you. We stand in solidarity with you, and you know that. And every young woman and girl has the right to compete safely and fairly.
The justices will decide whether boys can take part in girls' and women's sports. Lower courts in Idaho and West Virginia have ruled that bans violate the Title IX civil rights law. The states want the Supreme Court to overturn the federal court's decisions and reinstate their laws. Former President Bill Clinton could soon face contempt proceedings. The Republican chair of the House Oversight Committee says he's starting that process. That's after Clinton failed to attend a hearing this morning on sex offender Jeffrey Epstein. His committee chair, James Comer.
I think it's very disappointing. As a result of Bill Clinton not showing up for his lawful subpoena, which again was voted on unanimously by the committee in a bipartisan manner, we will move next week in the House Oversight Committee markup to hold former President Clinton in contempt of Congress.
A spokesperson for the former president has said that Clinton knew nothing about Epstein's crimes. Former Secretary of State Hillary Clinton has a similar disposition scheduled for tomorrow. Her attorneys say she won't show up either. Lawyers for the Clintons are calling subpoenas from the committee invalid, saying they're legally unenforceable. Former Justice Department Special Counsel Jack Smith will testify publicly before Congress. The hearing will take place on January 22nd. The testimony will be before the House Judiciary Committee, which is scheduled for 10 a.m. Eastern. And committee chairman Jim Jordan confirmed the date yesterday. Smith brought 2 criminal cases against President Donald Trump. Both have since been dropped. Smith previously testified in private in December. During that session, he defended his investigation into the president, telling lawmakers the prosecutions were based entirely on Trump's actions. President Trump has said that the cases were an abuse of the legal system, citing political motivation. This morning, President Trump is again calling on Federal Reserve Chairman Jerome Powell to lower interest rates. This comes as some lawmakers on Capitol Hill are expressing concern over a new DOJ investigation related to the chairman. A couple of senators are blocking President Trump's Federal Reserve's nominees.
Republican senators, including Elisa Murkowski and Tom Tillis, are questioning the authenticity of an investigation into Chairman Jerome Powell. Now, in a bid to urge officials to quickly resolve the case, these senators are vowing to block President Trump's Federal Reserve nominees.
I very seldom disagree with the president, but I've disagreed with bad advice he's been given and acted on.
President Trump has denied knowledge of the investigation, though he previously threatened legal action against Powell, accusing him of incompetence. Senator Murkowski, the latest, joined Senator Tillis in ramping up the pressure around this investigation, raised concerns about the fact that this investigation revolves around project cost overruns, which she says are not unusual. This Department of Justice investigation started over concerns about Powell's handling of the renovation of the Federal Reserve's headquarters. Specifically, investigators are looking into whether Powell committed perjury when he testified to a Senate committee about the project last year. The project is over budget. It was originally approved for $1.9 billion, but now it's costing around $2.5 billion of taxpayer money. The Fed's inspector said that this increase in the price is due to the timeline extension and material costs. The White House Economic Council director yesterday told reporters at the White House that even if cost overruns on projects aren't out of the ordinary, it's still important to know where taxpayer money goes.
Seems like the Justice Department has decided that they want to see what's going on over there with this building that's, massively more expensive than any building in the history of Washington. I think that it's really important to understand where the taxpayer money goes.
Chairman Powell was quick to deny the allegations of the lawsuit and said that the Trump administration only launched it because he refused to lower interest rates to a level that President Trump is happy with.
The threat of criminal charges is a consequence of the Federal Reserve setting interest rates based on our best assessment of what will serve the public, rather than following the preferences of the president.
While some Republicans aren't comfortable with this investigation, others say it's serious and warranted. Speaker Johnson today doubling down on his previous comments.
If there's a credible allegation or concern that someone's lied to Congress, then the DOJ should investigate. I mean, across the board, no matter who it is, no one is immune from that.
Chairman Powell will be replaced in just a few months as he reaches the end of his term in May. Reporting from Washington, D.C., Melina Weisskopf, NTD News.
Dilbert cartoonist Scott Adams has died after a battle with prostate cancer. He was 68 years old. Adams' ex-wife Shelley made the announcement today. Dilbert was a satirical comic strip that made fun of American office culture. The series ran from 1989 to 2023. Adams also hosted a live stream podcast entitled Real Coffee with Scott Adams. President Trump took to Truth Social today to express his condolences to Adams' family, friends, and listeners. Trump posted, quote, "Sadly, the great influencer Scott Adams has passed away. He was a fantastic guy who liked and respected me when it wasn't fashionable to do so." Trump added that Adams will be truly missed. The Trump administration is stepping in to address higher electricity bills tied to the growing power demands of data centers. President Trump says Microsoft will be the first company to act, with changes expected to begin this week. In a Truth Social post, the president said his administration is working with major technology companies to secure their commitment and will have much to announce in the coming weeks. Trump says data centers are critical to economic growth, but tech companies should cover their own power costs. Microsoft has not publicly responded to Trump's comments, though the company has previously said it works to prevent data centers from driving up local electricity prices. The issue comes as data centers account for a growing share of US electricity use amid a push to expand artificial intelligence infrastructure. Treasury Secretary Scott Bessent held a meeting of finance ministers from G7 countries and their major economies yesterday. The agenda included discussing ways to secure and diversify supply chains for critical minerals, especially rare earth elements.
So in this meeting, participants from various countries, they discussed their experience, the steps that they are taking in making the supply chain resilient, especially technology for refining, processing the mineral ores so that high quality critical minerals, especially the rare earth, permanent magnets, those kind of materials can be secured in a long term, in a sustainable manner.
The meeting was attended by G7 members, including Canada, Germany and Japan. Representatives from Australia, India, Mexico and South Korea were also there. One topic was reducing reliance on China for critical minerals. China often uses its position in the rare earth market to negotiate deals and has imposed strict controls on rare earth exports. Representatives also discussed funding for new projects to support sustainable extraction and processing. The Transportation Department says new regulatory changes could save Americans about $600 million a year while maintaining safety standards. Transportation Secretary Sean Duffy announced the reforms yesterday. He is directing the Pipeline and Hazardous Materials Safety Administration to modernize decades-old rules. The one change updates pipeline regulations to reflect advances in technology. It allows operators to avoid unnecessary replacements and save more than $460 million annually. Another rule cuts compliance costs for transporting fuel by cargo tank, generating an additional $145 million in savings. The department is also easing compliance enforcement in regions affected by the national energy emergency, aiming to lower energy costs for families while prioritizing safety. The Department of Homeland Security is setting up a new office ahead of the 2026 FIFA World Cup. The new office announced yesterday it aims to speed up the deployment of drones and counter-drone systems. It also plans to complete a $115 million deal this week for counter-drone tools for security at America 250, the 250th anniversary of the country's independence, as well as the 2026 FIFA World Cup. It's expected to be the biggest World Cup event ever, jointly hosted by the United States, Mexico and Canada. 11 of 16 host cities are in the US. DHS says the new office will guide investment in drone technology as well as address the growing use of drones by criminals. President Trump is in Michigan today, and he's now visiting a Ford factory which makes F-150 pickups, the best-selling domestic vehicle in the U.S. Let's take a look.
The election because I'm the tariff person. And everybody now admits that I was right on tariffs. And I hope that we win the Supreme Court case.
Mr. President, what about the raw materials coming in from countries like Canada? How do these companies deal with the fact that...
Well, we get it, but we have a lot of our own raw materials. And, you know, the word raw and rare are a little bit of a misnomer. They're not very rare. You have a lot of places that want to sell us material, and we get it from a lot of different countries. And we have a lot of rare earth and raw materials.
Senator Tom Tiller says that the subpoena, grand jury subpoena to the Federal Reserve Chairman was a little excessive. What do you think about that?
Well, that's why Tom's not going to be a senator any longer, I guess, right?
Well, what do you think?
But I like Tom Tiller. He's a nice guy. But look, he's not going to be a senator any longer because of views like that. We have a bad Fed chairman. He's bad in a lot of different ways, but he's bad because his interest rates were too high. And today we had a great inflation report. And today we had a really great growth report. So we have great growth and low inflation. And we're doing very well.
Do you think there's going to be a rate cut, though, with the inflation?
I don't know. With this guy, you don't know. He's got some problems. But what he also did, he's renovating a small building. It's the most expensive construction job in history. And it's only a renovation. I could have done that job for $25 million. They're spending billions and billions of dollars. He either doesn't know what he's doing or it's worse than that. And you know what I mean by what. So hopefully he'll be out of there soon.
Does the president impact your timing on being the Fed chair?
No.
When do you expect to do that now?
I don't know, sometime in the next few weeks.
Of the big three, Ford makes most of its products right here in the United
80%.
States. 80%.
That's a big advantage for Ford.
Is that the reason that you came here?
No, I came here because we're friends, three of us, because I have helped the company a lot. I mean, as an example, trucks. I put a 25% tariff on trucks coming into the United States, and their truck business went through the roof.
You said to Iran this morning that help is on the way for protesters. What did you mean by that? What kind of help?
You're going to have to figure that one out. I'm sorry.
How many people have been killed in Iran?
Nobody's been able to give me an accurate number. I have heard numbers from everything's a lot. One is a lot. But I've heard numbers much lower and I've heard numbers much higher. We'll be knowing. We're probably going to find out over the next 24 hours. I think it's a lot.
In your first
it's too many, whatever.
Oil average around $53 a barrel. Is that the target for you for this term?
I'd love to see that, yeah. I mean, we're at 68. We're at 58 now. I'd like to see 53. Thank you very much.
That was President Trump speaking live from the Ford factory in Michigan. Okay, the number of reported deaths in Iran keeps rising. President Trump is now directly calling on the Iranian people to dismantle institutions, saying help is on its way. Trump took to social media this morning saying, Iranian patriots, keep protesting, take over your institutions, save the names of the killers and abusers. They will pay a big price. Trump also announced that he cancelled all meetings with Iranian officials until the regime stops killing protesters. The president ended the message by saying, "Help is on its way. Make Iran great again." Trump previously said he's considering military options to support the Iranian people and warned the regime against killing protesters. However, the human rights activists news agency now says almost 2,000 demonstrators have been killed in more than 2 weeks of protests. Here's more on the situation in Iran.
President Donald Trump is ramping up pressure on Iran, which is facing its largest anti-government protests in years. On Monday, Trump announced that any nation doing business with Tehran will face a 25% tariff on U.S. trade. He called the order final and conclusive, but is yet to release further details. Iran, which already faces heavy U.S. sanctions, counts China, the United Arab Emirates, and India among its top trading partners. The protests in Iran began after soaring prices and economic hardship, but have since escalated into calls for the fall of the Iranian regime. The U.S. has warned its citizens in Tehran to consider leaving by land to Armenia or Turkey due to the protests. The situation has rattled global oil markets, pushing prices to 7-week highs on Monday due to fears of supply disruptions.
The foreign ministers of Denmark and Greenland are expected to meet with Vice President J.D. Vance and Secretary of State Marco Rubio. Today's face-to-face comes amid President Trump's push to take control of the Arctic island. The two foreign ministers requested the meeting. Trump first floated the idea of U.S. control over Greenland in 2019 during his first term. He says U.S. control of the Danish territory is necessary to counter threats from Russia and China. Denmark's defense minister said he would participate in a meeting with NATO's Secretary General in Brussels next week. Greenland's foreign minister is expected to attend that meeting as well. The BBC has filed a motion to dismiss President Trump's $10 billion lawsuit. The president is suing the British broadcaster for editing his speech from January 6, 2021. Trump contends that the BBC defamed him after it combined separate parts of his speech that were 50 minutes apart. As a result, the splicing of the footage made it appear that he had directed supporters to storm the US Capitol. The segment omitted a section in which Trump called for peaceful protest. The BBC argued that the court in Florida lacked jurisdiction because it did not broadcast the program in Florida. The organization also said the president can't prove damages because he was re-elected after the segment aired. French farmers drove around 350 tractors through Paris toward Parliament today to protest an EU trade deal with South America. The demonstrators say the agreement threatens their livelihoods. French President Emmanuel Macron and his government opposed the deal. However, the agreement is expected to be signed in Paraguay Saturday because it has support of the most other EU countries. A number of European farmers have long denounced the trade deal with Brazil, Argentina, Bolivia, Paraguay and Uruguay. They argue the move will flood the market with cheaper imports. A visiting member of Canada's Parliament acknowledged Chinese aggression toward Taiwan today ahead of Prime Minister Mark Carney's visit to China. The Canadian lawmaker pushed for diplomacy while in the Taiwanese capital of Taipei.
We reject the normalization of intimidation, of military coercion, of attempts to rewrite international norms through force. We believe that resilience, economic, institutional, and societal, is built through strong partnerships, also grounded in freedom, in democracy, in the rule of law, and in human rights.
Canada has no official diplomatic ties with Taiwan. However, the relationship between the two countries has deepened as China ramps up military threats against the democratic island. Two lawmakers from Carney's Liberal Party ended a visit to Taiwan early this week, citing advice from the Canadian government. Carney is expected to discuss trade and international security during his trip to China. President Trump is visiting Detroit today to refocus attention on U.S. manufacturing and his efforts to tackle high consumer costs. What we know about his schedule coming up.
that truly matters for each and every one of us. This is what you've been waiting for. See it at least once in your lifetime. Shen Yun. Get tickets now at shenyun.com.
Food. It fuels our bodies, nourishes our spirits, and brings us together. Because we all need nutritious food to thrive.
Food gives me energy and it also helps me focus.
But not everyone knows where their next meal is coming from. And 1 in 7 people in America face hunger. It's tougher than ever for too many of us. But the simple truth is, ending hunger is possible, and it starts with you. Call or go online to helpfeedingamerica.org and give $19 a month, just 63 cents a day, to help families in your community facing hunger. Feeding America works from coast to coast with partner food banks, food pantries, and meal programs. Your monthly gift delivers food where it's needed most, puts fresh food on the table, and helps kids have healthy meals all year round, even when school is out.
You can see the difference with the kids when they're full. Food is everything.
Please call the number on your screen or go online to helpfeedingamerica.org. Give $19 a month. Your first gift can double an impact. And we'll send you this free canvas grocery bag as a reminder of how you're helping to end hunger for good.
When it comes down to it, it's about taking care of your family first and the loved ones that you need to provide for.
Food donations help me tremendously, and I'm very grateful for the food bank.
I have hope. The simple truth is, ending hunger in America is possible. You can help make it happen. The need is urgent. Call or go online now to helpfeedingamerica.org, and your gift can double in impact.
Shop Mathis Home and save during the annual clearance event for huge discounts on all the latest styles. Here's a great value. This sofa from Ashley is a bestseller. It's just $4.99 and comes with 2 accent pillows. Upgrade to Motion with this sofa that has plush pillow top arms and 2 recliners built in. Clearance priced at just $7.99. They're in stock now with fast free delivery. For the best value, come to the annual clearance event at your furniture superstore, Mathis Home.
President Trump is traveling to Michigan today with stops planned in Detroit and Dearborn as he highlights manufacturing and economic priorities. The president is set to address the Detroit Economic Club during an event at Motor City Casino. The club says it will be Trump's 3rd address there. On the campaign trail in 2024, he joined a list of speakers, including former presidents Jimmy Carter, Ronald Reagan, Bill Clinton, and Bush's senior and junior. Trump will also tour Ford Motor Company's historic Rouge Center, where the automaker builds its F-Series trucks. Ford says the visit will showcase American workers putting the automobile within reach of every American. Trump was last in Michigan in April 2025 to celebrate the first 100 days of his 2nd term. Here's the president speaking to reporters before departing the White House earlier. Take a listen.
We're going to Detroit. We'll be talking about how well the economy is doing. As you know, the inflation numbers just came out, and we have very low inflation. So that would give Tulane Powell the chance to give us a nice, beautiful, big rate cut, which would be great for the country. But rates are falling also, and growth is going up. We have tremendous growth numbers, so growth is going up. So I'll be talking about that today in Detroit. It's a big speech, and I can only say that the country is doing well.
And speaking now on the Middle East, the Trump administration has designated 3 branches of the Muslim Brotherhood as terrorist groups. The Treasury and State Departments announced the actions today, affecting Muslim Brotherhood chapters in Lebanon, Jordan and Egypt. The Trump administration said these organizations pose a risk to the US and American interests. President Trump ordered the designation last month. The three branches and their new members now face US sanctions. Secretary of State Marco Rubio said in a statement, quote, the United States will use all available tools to deprive these Muslim Brotherhood chapters of the resources to engage in or support terrorism. Jordan and Egypt have also banned the Muslim Brotherhood in their countries. Other US allies in the region, such as Qatar and Turkey, are more tolerant of the organization. The Trump administration is ending temporary protected status for thousands of Somalis in the United States. White House Press Secretary Caroline Leavitt says they'll be required to leave by March 17th. In a statement to Fox News Today, DHS Secretary Kristi Noem said, quote, temporary means temporary. She added that country conditions in Somalia have improved to the point that it no longer meets the law's requirement for temporary protected status. She also said allowing Somali nationals to remain temporarily in the US is contrary to our national interests. Trump said in November that he was terminating deportation protections for Somalis living in Minnesota. The decision comes as federal authorities investigate reports of widespread fraud in the state. A New York City Council employee was detained by ICE during a routine immigration appointment on Long Island yesterday. The Department of Homeland Security says he was there illegally and did not have work authorization. Council Speaker Julie Menin said the employee, a Venezuelan national, works as a data analyst and has a work visa. She called the detainment government overreach. DHS Assistant Secretary Tricia McLaughlin disputed those remarks and said he has a criminal record, including for assault. In a post on X, New York City Mayor Zohran Mamdani called the arrest an assault on democracy, on New York City and our values. He called for the employee's release and said he would continue to monitor the situation. The Supreme Court today began hearing oral arguments in two cases over transgender sports. The justices will consider the legality of state laws banning men from women's sports. Idaho and West Virginia have imposed such laws but face legal challenges. They're appealing to the High Court to overturn the lower court's decision that sided with their challenges. Supporters of the bans, including the Trump administration, argue they protect women's sports, while opponents argue the bans discriminate against people who identify as transgender.
Idaho's law classifies on the basis of sex because sex is what matters in sports. It correlates strongly with countless athletic advantages like size, muscle mass, bone mass, and heart and lung capacity. Tragically, but not surprisingly, male athletes have even injured female athletes in many sports. If women don't have their own competitions, they won't be able to compete. Gender identity does not matter in sports, and that's why Idaho's law does not classify on the basis of gender identity. It treats all males equally and all females equally, regardless of identity, and its purpose is exactly what the legislature said: preserving women's equal opportunity. In fact, it's our friends on the other side who want to classify based on gender identity. They're seeking special treatment for males who allegedly lack an unfair advantage, but only if those males also identify as transgender. Denying special treatment isn't classifying on the basis of transgender status. It's consciously choosing not to.
That means HB 500 is aimed at controlling for sex-based biological advantages, not for all of the many reasons one athlete may be better than another that have nothing to do with sex. On the preliminary record in this case, and as the experts below agreed, circulating testosterone after puberty is the main determinant of sex-based biological advantage that HB 500 sought to address. And on this record, Lindsay Hecox has mitigated that advantage because she has suppressed her testosterone for over a year and taken estrogen. HB 500 thus fails heightened scrutiny as applied to Lindsay and transgender women like her who have no sex-based biological advantage as compared to birth-sex females. That analysis would come out the other way for the untalented cisgender boy. He would have the same sex-based advantage, the circulating testosterone, he just would not be as good at sports. It also would come out the other way here, for example, if a transgender woman had gone through a male puberty and had not mitigated that advantage.
As the US Supreme Court hears arguments in blockbuster cases challenging transgender sports bans, House Speaker Mike Johnson showed his support outside the courtroom.
I'm the dad of 2 girls. My girls were athletes as well. We know what's fair and what's right. I'm proud to stand with you as we fight to protect female-only spaces and sports, and truly the future of women's athletics. Every Republican here in this House is with you. We stand in solidarity with you, and you know that. And every young woman and girl has the right to compete safely and fairly.
The justices will decide whether boys can take part in girls' and women's sports. Lower courts in Idaho and West Virginia have ruled that bans violate the Title IX civil rights law. The states want the Supreme Court to overturn the federal court's decisions and reinstate their laws. Former President Bill Clinton could soon face contempt proceedings. The Republican chair of the House Oversight Committee says he's starting that process. That's after Clinton failed to attend a hearing this morning on sex offender Jeffrey Epstein. Here's committee chair James Comer.
I think it's very disappointing. As a result of Bill Clinton not showing up for his lawful subpoena, which again was voted on unanimously by the committee in a bipartisan manner, we will move next week in the House Oversight Committee markup to hold former President Clinton in contempt of Congress.
A spokesperson for the former president has said that Clinton knew nothing about Epstein's crimes. Former Secretary of State Hillary Clinton has a similar disposition scheduled for tomorrow. Her attorneys say she won't show up either. Lawyers for the Clintons are calling subpoenas from the committee invalid, saying they're legally unenforceable. Former Justice Department Special Counsel Jack Smith will testify publicly before Congress. The hearing will take place on January 22nd. The testimony will be before the House Judiciary Committee, which is scheduled for 10 a.m. Eastern. Committee Chairman Jim Jordan confirmed the date yesterday. Smith brought 2 criminal cases against President Donald Trump. Both have since been dropped. Smith previously testified in private in December. During that session, he defended his investigation into the president, telling lawmakers the prosecutions were based entirely on Trump's actions. President Trump has said that the cases were an abuse of the legal system, citing political motivation. This morning, President Trump is calling again on Federal Reserve Chairman Jerome Powell to lower interest rates. This comes as some lawmakers on Capitol Hill are expressing concern over a new DOJ investigation related to the chairman. A couple of senators are blocking President Trump's Federal Reserve's nominees.
Republican senators, including Lisa Murkowski and Tom Tillis, are questioning the authenticity of an investigation into Chairman Jerome Powell. Now, in a bid to urge officials to quickly resolve the case, these senators are vowing to block President Trump's Federal Reserve nominees.
I very seldom disagree with the president, but I've disagreed with bad advice he's been given and acted on.
President Trump has denied knowledge of the investigation, though he previously threatened legal action against Powell, accusing him of incompetence. Senator Murkowski, the latest, joined Senator Tillis in ramping up the pressure around this investigation, raised concerns about the fact that this investigation revolves around project cost overruns, which she says are not unusual. This Department of Justice investigation started over concerns about Powell's handling of the renovation at the Federal Reserve's headquarters. Specifically, investigators are looking into whether Powell committed perjury when he testified to a Senate committee about the project last year. The project is over budget. It was originally approved for $1.9 billion, but now it's costing around $2.5 billion of taxpayer money. The Fed's inspector said that this increase in the price is due to the timeline extension and material costs. The White House Economic Council director yesterday told reporters at the White House that even if cost overruns on projects aren't out of the ordinary, it's still important to know where taxpayer money goes.
Seems like the Justice Department has decided that they want to see what's going on over there with this building that's, massively more expensive than any building in the history of Washington. I think that it's really important to understand where the taxpayer money goes.
Chairman Powell was quick to deny the allegations of the lawsuit and said that the Trump administration only launched it because he refused to lower interest rates to a level that President Trump is happy with.
The threat of criminal charges is a consequence of the Federal Reserve setting interest rates based on our best assessment of what will serve the public, rather than following the preferences of the president.
While some Republicans aren't comfortable with this investigation, others say it's serious and warranted. Speaker Johnson today doubling down on his previous comments.
If there's a credible allegation or concern that someone's lied to Congress, then the DOJ should investigate. I mean, across the board, no matter who it is. No one is immune from that.
Chairman Powell will be replaced in just a few months as he reaches the end of his term in May. Reporting from Washington, D.C., Melina Weisskopf, NTD News.
Dilbert cartoonist Scott Adams has died after a battle with prostate cancer. He was 68 years old. Adams' ex-wife Shelley made the announcement today. Dilbert was a satirical comic strip that made fun of American office culture. The series ran from 1989 to 2023. Adams also hosted a live stream podcast entitled Real Coffee with Scott Adams. President Trump took to Truth Social today to express his condolences to Adams' family, friends, and listeners. Trump posted, quote, "Sadly, the great influencer Scott Adams has passed away. He was a fantastic guy who liked and respected me when it wasn't fashionable to do so." Trump added that Adams will be truly missed. The Trump administration is stepping in to address higher electricity bills tied to the growing power demands of data centers. President Trump says Microsoft will be the first company to act, with changes expected to begin this week. In a Truth Social post, the president said his administration is working with major technology companies to secure their commitment and will have much to announce in the coming weeks. Trump says data centers are critical to economic growth, but tech companies should cover their own power costs. Microsoft has not publicly responded to Trump's comments, though the company has previously said it works to prevent data centers from driving up local electricity prices. The issue comes as data centers account for a growing share of US electricity use amid a push to expand artificial intelligence infrastructure. Treasury Secretary Scott Bessent held a meeting of finance ministers from G7 countries and other major economies yesterday. The agenda included discussing ways to secure and diversify supply chains for critical minerals, especially rare earth elements.
So in this meeting, participants from various countries, they discussed their experience, the steps that they are taking in making the supply chain resilient, especially technology for refining, processing the mineral ores so that high quality critical minerals, especially the rare earth, permanent magnets, those kind of materials can be secured in a long term, in a sustainable manner.
The meeting was attended by G7 members, including Canada, Germany, and Japan. Representatives from Australia, India, Mexico, and South Korea were also there. One topic was reducing reliance on China for critical minerals. China often uses its position in the rare earth market to negotiate deals and has imposed strict controls on rare earth exports. Representatives also discussed funding for new projects to support sustainable extraction and processing. President Donald Trump is speaking in Michigan now. Let's tune in.
It's going to turn out this well, though, really. I told you we're going to do a lot of things. Nobody thought it was going to turn out like this. This has been crazy. But it's a true honor to be back at the Detroit Economic Club with the businessmen and women who are really the economic engine of America. That's what you are. You've become more of that since I've been in, a lot more. Factories and plants were going to close, and now they're going 24 hours. I just left Bill Ford. He's running his plant, 150 plant, 24 hours a day, round the clock. It wasn't running that way two years ago, I can tell you. But it's the complex that Ford Motor Company so cherishes. It was a pleasure to see that the crown jewel of Detroit auto industry is what they call it, is still going after 100 years. Can you imagine over 100 years? I especially want to thank the president of the Detroit Economic Club, Steve Gregorian. Where's Steve? Steve? Where's Steve? Hi, Steve. Nice looking man. Nice looking guy. And board chair Sandy Pierce. Thank you very much, Sandy. Thank you very much. And we have some very special people here. We have a man who's doing a fantastic job. I get angry at him every once in a while, but very, very seldom, because he's got what it takes. Treasury Secretary Scott Bessent. Scott? Hi, Scott. Hi, Scott. What a good guy. He's got a good pulse, doesn't he? Good pulse of what's going on. Thank you, Scott. He's been great. Michigan House Speaker Matt Hall. Matt. Hi, Matt. We did good in Michigan, Matt. We won the whole thing in Michigan, didn't we, huh? 3 times we won. You know that, right? They didn't give us credit the second time, but we won the second time. But we made the last one, Matt, too big to rig. Right? That's what you got. That's the only way you win races in many cases. I got to tell you, it's too bad. I think they should get voter ID. Wouldn't it be nice? The Democrats are totally against voter ID. Who's against voter ID? How can you even campaign? We are against voter ID. How do you not get voter ID? You know what it means, Matt, right? When you're against voter ID, you want to cheat. That's all. There's only one reason you want to cheat, and they do cheat. They're terrible. Michigan Senate Republican leader Eric Nesbitt. Thank you, Eric. Thank you. Look good, Eric. State Senator Jim Runstad. Jim, thank you. Thank you. Thank you, Jim. Former Congressman Mike Rogers, who's running for the Senate, and he'll be a great senator. And he's going to be a great senator. He was a great congressman, and then he left. He went on to very big things. He did well, no matter where he was. And I think they took that away from you last time. I'll be honest with you, Mike. I really do. I don't like to get things going. I don't like to be controversial at all. But they rigged the election on you. Mine was too big to rig. You won. I'm telling you, you won. But you're going to do great this time. He's a great guy, actually. He's to be an amazing senator. Thank you. Thank you for being here, too, Mike. Special envoy to Iraq, Mark Savaya. Mark. Hi, Mark. Thank you. Great job you've done. This guy, he negotiates better than anybody around. Thank you. You need it. With Iraq, you need it. You need to be a good negotiator, Mark. I also want to thank Michigan's great congressional delegation. They're amazing. That's been back in Washington due to a very important vote that's coming up. They had a choice. Sir, we want to be with you, but if we're not with you, we're going to lose. But we'll still be with you. I said, no, I'd rather have you win. Don't worry about it. So we're going to win the vote. Representatives Lisa McClain, Jack Bergman, John Molinar, Bill Heisinger, Tim Walberg, John James, and Tom Barrett. They're great people, every one of them. And as many...
That was President Trump speaking live at the Detroit Economic Club in Michigan. And we'll cover more news right after this break.